Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that
Alex stole it as well.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict's live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po rin,
Is that correct?
That's literally not true. I didn't ask you to interrupt me. Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I am sorry I'm late. I got carried away. I was watching... oh, sorry. That was still playing. I was watching the Corey Richins sentencing again for some reason. I don't know why. And I got a little carried away and started surfing the web and talking to Mrs. R.A. Next thing you know, I'm 20 minutes late, so I apologize. I'm in trouble. I'm sorry. Oh, yeah. Welcome all. Welcome. Good to have you here. Goldilocks is in the house. Goldilocks, good to have you. Squirrel. It's going on my record. Add it in the long column of failures. Long column of failures. I thought you forgot to hit the start button. The fact that that's happened so much is funny. All right, but we are going back to court, and we're doing so knowing that the internet is secure in Kim's hands. Kim R., congratulations. You won the internet. You were first in chat this afternoon. Long time ago, 20 minutes ago, you were here. More than that. You're getting as bad as that Rob guy. I started... like 4 minutes ago, I started the live stream. That's when I first hit the button. And then I have to go through like the checklist of things I have to click in the right order to make sure they work. I realized that was 19 minutes later than it should have been. But it was before 2:20, which is my new time. All right. One of the side quests. I hope it was a fun side quest. It was. It was a fun side quest. It's a good Monday. Kim R. I'm back. I'm back, Kim. Thank you very much. Appreciate it. We're going to go to court really quickly because nothing's happening. I wanted to show you that, which is important. So let me fix the timer as well. Looks like we need it. Just move the teensy bit over like so. Does that work? And then I'm going to take a little bit of the left. Make some room over there for when it becomes a 2 in about 7 minutes. As 7:47 takes off with the shorter checklist, maybe so. But we have more people here than are on a 7:47, so it's harder. It's harder. All right. Sweet Tat, you asked like 5 minutes if we were late. My comment was deleted. I'm so sorry. It might have been me. You're good. I'm the one that was out of line. I do apologize. Where we are right now, if we can get some audio going, we're in 6, right? No courtroom audio right now. We're in verdict watch, and we're coming up on 2 hours of deliberation time. Probably the first hour of that is most likely lunch. We know that the lunch arrived right before the jury went out. I started the timer when they went out, and it took about 15 minutes before the jury got the evidence from the courtroom. But we do believe they are, in fact, deliberating right now with the evidence in the room. Most of it, not the pew-pews, not the ammunition, things like that, but most of the rest. We do have a new trial to start tomorrow. It'll go about 2 days. Let's see. I don't think your comment was deleted. We joke about Recovery Addicts being late all the time. You guys do, and it's fine. I am. I hope it didn't get deleted. It might have had a word in there. You know what it is? Sometimes we add words temporarily to the ban list because there's a certain scenario where we're trying to avoid a spoiler in a situation where we're a few minutes behind or something, and so we put certain words, sometimes words that are normally not a problem, on the ban list, and sometimes I forget to take those words off, and then it's like, why can't I say, and Why can't I say the anymore? Well, I put the on the ban list for a good reason, but now I can't remember what it was. All right. Sounds on, but it sounds very quiet. Check 1 2. Check 1 2. I'm coming in at -2 decibels on my meter. So I mean that's a broadcast meter though, so that's good. Zero's pegged. Oh no! Trial TV Live is. I don't know what happened. I don't know what happened with that trial specifically either. Funny enough, pegged was one of the banned words. Yes. All right. We do have, let's see. I'm going to be watching. I'm not going to bring you guys in with this one, but the court from Utah has sent me the information regarding a civil case. And we normally don't follow civil cases, especially ones that are basically divorce cases. But this is Dakota Mortensen versus Taylor Frankie Paul. And there's a protective order review going on. This is, I believe, Taylor. I'm not sure which is the guy. Is Dakota the girl, or is Taylor the girl? Anyway, it's an interesting case where the wife was on a reality show, the Wives Show, Reality Wives Show. Was going to be on Bachelorette, but that got canceled after drama, her throwing chairs at the husband and with the presence of the child, things like that. Taylor's the girl. Okay. All right. I don't watch much TV, if you guys haven't noticed. I don't watch much TV. But I'm going to keep an eye on that one just to see what's happening. Law and Crime is pool on that one. So we'll see what happens. But we're not going to watch it here, just so you know. I'll just watch it. I'm going to watch it here on this little screen. That's what I'll do. Let's see. They weren't married. Then how was she one of the wives on the Wives Show if she wasn't a wife? You need to be a wife. It's not another pit trial that I know. The next case, Josh has one for us out of. Let's see if I can find it. Bay County, Florida, with dual defendants, and this was aggravated battery with deadly weapon, robbery with a firearm, and robbery with a firearm. Slated for tomorrow. So, is that Judge Clark, Josh? I think it's with Judge Clark. No verdict yet. About 2 hours in. Please tell us we're not going to stare at this wall for the next 3 hours. No, Laura. No, we're not going to stare at the wall for 3 hours. I was just saying hi and getting warmed up. So let's take a look. We are going to do a little bit of court hopping this afternoon as we're on verdict watch because we want to be able to jump to. In any case, you guys, you remember this one? This lady has the fanciest. I don't know what's it called, like a doily when the. You know this one, when they have the neck.
Who's the first person you told about a pistol barrel in your mouth?
Excuse me?
That was today, wasn't it? Right?
It was.
Yeah. Okay. You didn't tell any police person in the uniform, you didn't tell a detective, you didn't tell Mr. Pfeiffer, you haven't told anybody before today. Is that true?
Yes, it is.
Thank you. This lady, Minnie, she related to you?
No.
Who is she?
We were friends.
Okay. Did you work together?
No.
All right. Thank you.
I feel like we're up in the rafters, spying down from the ceiling.
So, Mr. Brooks, your testimony is that he threatened to kill you, but you're still here. And he threatened to do some other things, but apparently failed to follow through. Does that sound right to you?
Yes.
Okay. And You're accusing Mr. Brooks of having trashed the place there on Eaton Rapids Road?
Yes.
And how is it that you believe it was him?
Because he's admitted it in text, first of all. And then another time, I had installed cameras after he broke in, like in the short.
Another time what?
He had broke in.
I had installed
That time when
cameras.
he broke in with the pictures. After that, I told him, don't come back to my house because I'm installing cameras. He came back a couple of days later and tried to break in, and I got him on camera breaking in the house.
And that, I'm sorry, were you finished?
Yes.
And that video footage, that clearly showed Mr. Brooks entering the Eaton Rapids Road address?
Yes, he opened the window, tried to get in the window.
Okay.
The alarm went off.
And so you gave that video footage to law enforcement? Yes?
Yes.
All right. Do you recall who you gave it to?
Probably Detective Brandon.
Now, was that something that you uploaded or was it something you physically handed? How did that go about?
Uh-oh.
I don't really remember, but I know I have the video still of him breaking in my house from the Xfinity.
We have to jump.
Came in through a window?
Yeah, that's where the alarm went off. But he didn't jump through the window in that time because like the alarm went off and it probably like scared him. And like after he seen the camera, he put his mask up, but the camera had already clearly caught his face.
Okay, so we have to jump that one. We jumped in. I stumbled upon it, and I joined because of the caller. Didn't know the content was unfriendly. Let's see. Thurston County, I believe, is doing Thurston County things. Let's check in with them.
Defense is with you, Ms. Crisco.
Has not means that's actually Mr. Swenson's matter.
Okay.
I don't know.
All right, Mr. Swenson, I see you on Zoom there. You ready with Joshua Pratt? We're here for first pretrial.
Your Honor, yes, Mr. Pratt needs to get going. If we could just leave his date set at this time, we should have confirmation already set, and I will reach out to Mr. Pratt and schedule a meeting.
All right. Mr. Pratt, your dates have already been set. Looks like we've got trial confirmation for you on June 30th at 10 o'clock. Did you receive notice in the mail of your court dates?
Yes.
Okay. And how about text message reminders?
I got that too.
Okay. We'll see you back on June 30th.
June 30th. Okay. Thank you.
Thank you, sir. All right. And then I know Miss White was ready to go on her matter.
Who's a good dog?
Yes, good morning, Your Honor. That's the Alana Woodward matter.
Alana Woodward. Miss Woodward? I saw you on Zoom. There you are. All right. Good morning, ma'am.
Thank you, Lois. Thank you, all of you. I'm sorry, I was not paying attention.
We're here for a compliance review hearing.
Oh, should we go find
Yes,
out?
Your Honor, this is, I believe, the parties, when Ms. Woodward had entered the stipulated order of continuance, the parties had agreed that the anger management classes that Ms. Woodward had already completed would suffice for the agreement with the city. I believe it sounds like probation wasn't satisfied with whatever it is that Ms. Woodward filed online, and we tried to get the hearing vacated, but probation wouldn't do that. So Lacey is satisfied and is not moving to take any action on Ms. Woodward's case.
All right. Let's see. I think I saw someone from probation. They may have jumped off though. Anymore.
Chris Garwood, DC probation.
Oh, there you are. Yeah, Mr. Garwood, are you here for this matter for Ms. Woodward? You're on mute.
You're mute.
Yeah.
Sorry, Your Honor. No, I am not here for this matter. I'm here on another matter.
Okay. All right. Thank you. Yeah. Okay. Let's see. Okay. Yeah, that may have been, it looks like I'm reading the court's email response, which is kind of standard for this type of filing for anger management. But if this was already accepted by the city of Lacey, the city of Lacey is the plaintiff here. They're the other party to the stipulated order of continuance. So if it's acceptable to the city, it's acceptable to the court. And it doesn't sound like the city's taken any action, wanting the court to take any action as far as revocation or anything like that. So Miss Eddie, it sounds like we're just going to take no action today and let the SOC continue.
Yes, Your Honor.
Okay. All right, Ms. Woodward. Well, I apologize. It sounds like there may have been some miscommunication maybe on our end. And it sounds like you're already doing what you need to do. So you're still on that stipulated order of continuance. Looks like that will be through February of 2028. Keep doing well. It doesn't sound like we have anything to address today.
Okay. Thank you.
All right. Anything further, Ms. White?
No, Your Honor. Thank you. Have a good day.
You too. Thank you both.
False alarm. No court business to conduct.
And let's see, Ms. Grisco, do you have, I know we're kind of addressing some 11 o'clock. Do you have any matters ready to go earlier?
I do for Mr. Dean Hardeck for 10:30. Who's Hardeck?
Mr. Hardeck, good morning. Looks like we're here for a first pretrial.
Yes, Your Honor. I was in talk with Mr. Hardeck today. I do have some concerns regarding competency. So I did send a 1077. Miss Eddie hasn't signed it yet because I just filled it out not too long ago. But we're asking for out of custody.
Hardeck.
Out of custody.
Number 1 at 10:30. All right. And let's see. So you sent that over to Miss Eddie.
Miss Eddie,
Yes,
and
I'm missing a couple things.
Sure.
But I forget to click. No, that's fine. That would be yesterday court. I didn't know. I was supposed to put that.
Don't forget to click.
It's a bit second. Oh, 7. Got it. I thought it said second. Okay.
The address.
Okay. Yeah. Thank you. And then, Ms. Goresko, do you have the proposed 1077 with you there?
I do. I was
Okay.
looking at one email address.
There we go. I'll put the timer back on the screen for you. Request for competency exam, 1077.
I didn't sign it, Your Honor. It didn't have the court's address on the last page of where the order should be sent. And so perhaps Madam Clerk knows what
Sounds like we've
address
got
that needs to come to.
Okay.
For the last line.
All right, Mr. Hardeck, good morning. All right, so Mr. Hardeck, Ms. Goresko here has indicated concern about ability to proceed today. And so what we're going to do is put the criminal case on pause for a period of 6 months. And that's going to give Ms. Goresko's firm an opportunity to work with some folks at Department of Social and Health Services to coordinate an evaluation on your ability to proceed on the case today. All right, so we're not going to take any action today except for I'm signing an order that will start the process for having that evaluation. And then we're going to set another court date out, a period of 6 months from today, so that will be out in December, but we'll give you notice of that. We'll come back.
They're backlogged 8 months to a year and a half.
Yeah, that's why we're setting it out so far. And so we'll want to check in 6 months, but then after that, we'll kind of see where everything is.
And have the charges dropped, though.
Right. So we're not talking about the case today, anything substantively about the case. It's just I'm going to order that evaluation, and then we're going to set another court date. So that's what we're doing today. Okay. Can we give him a notice for that?
And this might be one of the, I was just double checking one of the things of the proposed order. I believe council didn't.
Like it's.
It says the box was not checked for that. It's a serious offense as in 1077-665. And off the top of my head, I think harassment might fall into that category. I don't know if I think it matters.
I think we put, usually what I was told is to put the reserve on it.
I guess it just, for the purposes of today, Lacey's not stipulating that this does not in fact qualify as a serious offense.
All right, well, let's just take a look here quickly. Yeah. Yeah. So I'm going to make a modification under 1077-665-1E. The charge of harassment is a non-felony charge. That is considered a serious offense for purposes of competency restoration. So I'll make that change on the order. Thank you. Okay, that doesn't change anything about next steps, sir. So we're still going to set out a next hearing is going to be December 7th at 9 a.m. We'll give you a notice of that hearing. And then we'll make sure to stay in communication with your attorney because they're going to help you coordinate that that competency evaluation.
And have the charges dropped because I didn't do nothing at the library.
Okay. All right, sir. Yeah, we're not going to talk about kind of what happens next. We're just staying focused on that evaluation and next court date for now. But stay in good communication with your attorney. And Ms. Crisco, if you want to grab that.
Apparently, we won't talk about what happens at the library.
Yeah. All right. So stay in good communication with your attorney, sir, and we'll see you back here in December, okay?
Can I have my highlighter back?
I was hoping I could use all the yellow.
Oh, no. I need it, though.
Okay.
Thank you. You don't.
He tried to steal her pen.
Mr. Hardick, you're free to go, sir. Thank you so much.
Oh, man.
That's great.
I gave that to them, okay?
Okay.
And Ms. Crisco, if you're ready with...
I do have another person. Mr.
Hardick, if you could go.
Provost.
Mr. Provost, okay. And Mr. Hardick, you're welcome to stick around and gather your things, but we do need to use that chair.
Okay.
Yeah, no, thank you, sir.
Do you have any yellow highlighters that can use?
I don't think we do, sir.
I do need that one. Yeah.
Okay.
Oh, hey, we got you covered, sir. Why don't you come on up here?
Ms. Hart, I'll have it.
Thanks.
The clerk's like, let's give him a highlighter. He wants a highlighter. There you go. That's for you to keep.
Oh, okay.
No, you'll need one. And you're Mr. Prevost?
Yes.
All right. Good morning, Mr. Prevost. Looks like we're here for preliminary fair to comply with treat. Looks like we're on a SOC. Okay. Yeah, number 4 at 11. All right, and okay, I'll let the parties here take a look at. It's been brought in.
Lost.
Thurston County has some wild cases. They've got people of all types. Obviously, mental competency is an issue in the last case, and that's going to be looked at. They've got a 6-month period to review that and figure out what's actually going on. But I love that they gave him a highlighter. That's a good thing. We may jump to the burn pit trial. I don't know. We're looking. We've got another one that we had lined up for tomorrow and the day after. But we might have to jump. I don't want to jump before we have a verdict, because then we'll be in the middle of something really interesting, and then boom. As a matter of fact, let's take a quick peek what's happening. Let's see where. Let's go to 6, shall we? Looks like we have some action. Just waiting for the defense table. Okay, Lady in Blue is scrolling up and down, swiping left and right. What app is that again? What's up with Wisconsin and dudes named Zachariah being criminals? That's the burn pit trial. Missing wife. Is that a no bottle trial? Oh, got some noise. Got some sound. Got some bailiffs. We might have something going on. Let's do a quick check on the interwebs and see if we have any news. Nothing official that I can see.
Don't miss the forest for the trees.
Clerk's there. Bailiff's giving hugs. Deputy from Live on Patrol is there. There we got defense is showing up. If nothing else, I think we have a question. Let me
Alex stole it.
bring back the timer here. About an hour of this was lunch for the jury, so Dale's standing there with his arms crossed, staring at the rest of his team, who are all staring at their phones, except for the lady in blue. She's trying to stare around Dale, but Dale's blocking the line of sight. Here comes Mr. Chow. We definitely have something happening here. Possibly a question. All right, let's see if we can get some audio here from the judge now that everybody is here. Not seeing any updates. Let's.
Judge, please read the instructions. With y'all's permission, I think I'm going to ask the poor lady exactly what part of the instructions they want. I don't
It's
know
a question.
if it would be necessary for them to hear my job, their job, and all that. All agree.
They want the jury charge.
Right. Envisioning something like, do y'all have a specific section? Okay.
Dude, you could just call Four men, four ladies.
Yes, maybe, let's start it that way. That suit everyone, just bring in the four ladies?
Just a minute, yeah.
Okay. That's fine. All right, just bring in the four ladies, please.
The four lady is going to be brought in. She has asked for if they could have a copy of the instructions. The judge does not like doing that, even though other judges do. There's no rule against it.
Yeah, and just for the record, I marked the note as court. Madam Forelady, we got your note about wanting us to read instructions again. Is there a specific provision in the instructions you have in mind, or does the jury want to have the entire thing read again?
They do not want the entire thing read again.
Okay.
We didn't know that we could have a portion of it read,
Okay.
but we did want to go over the aspects of malice, what constitutes malice.
Okay. All right. That was it.
Yes, and someone had spoke about what is the charge of murder and what are the things that would make him guilty of murder.
Okay.
And I think that's one and the same one we're talking about.
All right. Okay. Well, that's what we need to know. If you'll step, or you can just stay.
Okay.
And you can get. What I think I'll do is I'll just read the entire murder section and stop after that before we get into this, because I think it flows right into section now. So I'll just stop the section. Unless anybody has anything.
If I were defense,
All right, we're going to bring in the remainder of the jury, please, sir. Yes, sir.
I'd be a little nervous right now. I would much rather if they had a question clarifying what is reasonable doubt or what is can you tell us self-defense again? The whole jury is being brought in. They're going to read the charge as it relates to murder, the elements of murder. Specifically, malice as well was addressed. No lesser included. This is an all or nothing case. Either they charge him with murder or they set him free. Tower Hill Girl, they're asking if they could have jury instructions read to them, specifically the elements of murder and the definition of malice. Could go either way, but I think this... I think this would... I think it goes prosecution.
Ladies and gentlemen, jury, understand you would like to be recharged on how we define murder. So I'm going to recharge you on the murder portion of the instructions. The defendant is charged with one count of murder. The state must prove beyond reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you along with the other evidence in the case. You may give it the weight you decide it should receive. And that's it. I'm going to squeeze you back to your jury room, and if you have any other questions, if you need anything else, just let us know.
All right, hearing that again, I think that's a very friendly charge for the defense, considering the evidence that's been presented. The hatred, the ill will in your heart, with evil intent.
All right, any exceptions from the state? No, sir. Anything from the defense? No, sir. All right, we'll be at ease.
I think it's hard to say he had malice in his heart because he didn't say anything, mean beforehand other than stop. Drop it. No. The actions afterwards, especially the circumstances under which he was performing CPR, would, in the moment, saying call 911, trying to get help, assisting with the CPR. That might be. It doesn't stand to reason that it goes right in hand in hand from malice to that. Malice aforethought might be the hanging thing for the jury. So charges are malice, murder, or murder. I think malice murder is what they're charging. I think they have to say that he did it with malice. And it has to be the illegal act. I don't know. I think that could go either way there. All right. Where were we? We were up in Thurston County, but we might try to go somewhere else. Let's see. Mr. Aguirre is doing his thing with a different judge, not Judge Webster. Hold on one sec. Let's go to 7.
No, Your Honor.
All right. If you're going to get an attorney hired, I'd start that process as soon as possible if you haven't already. That way an attorney can get in and start looking at the reports and determine what can be done on your case.
Absolutely. Thank you.
All right. If there's nothing further, we'll be in recess. Have a good day.
Thank you.
Hang on.
Mr. Aguirre.
Let me jump to this. You guys are asking questions. Malice is evident in the chasing, I think. Malice is the hostility for what he thought was taken. Can you explain what you mean? We don't know what Mr. Chow was thinking in the moment. None of us can know. All we can do is look at the actions, and obviously the chase leading up to it is one of those actions we can look at. But his actions immediately afterward also were helpful in understanding. There was the only physical contact with the victim in this case afterwards, after the shot, was offering life support. Aside from moving the gun out of the way, which was the threat, you can say that there was disregard for life. I think there's an argument that could be said that it was actually in protection of life that he fired, if you believe Andy. So I don't think you can have both. We're not going to watch any new trial until the verdict comes in on this one. Until this one ends. Let's see. Mr. Aguirre did buffer crash out on that one. He's done. Let's go back to Judge Dad. If we can find him really quickly. I think it's this one. It's got to be earlier in the day. Apparently came down on somebody pretty hard earlier today. Okay, let's jump over there.
Morning. Infinity versus Ryan Messmore, 2403979.
Good morning, Judge. Cullen Geisler, P6902 Farm behalf of the plaintiff. Sorry, I dropped there for a second on Zoom.
Oh, you're fine. Who do I have out there? Jen Wiseman. There was proper service here, right, Jen? Of this. Well, first of all, for the record, the defendant failed to appear for creditor's exam. Did you file a proof of service with us indicating that you'd at least provided it by first-class mail?
Yes, sir. Back on, I believe we sent it out on April 16th. I also filed up with Mr. Messmore yesterday via email, sent him a copy. He did respond.
He did or did not?
He did. So I'm surprised he's not here yet.
Jennifer, we have that?
Yes, Your Honor. We have that proof of service filed with us on April 17th.
Show cause was issued. Defendant failed to appear. Bench warrant to issue.
On-site specialty cleaning and restoration is here, Judge.
What was the amount of this judgment again here, counsel? What do we have here? It looks like $75,39.43.
Correct.
I'm going to do a cash bond of $1,000. Okay.
Okay.
You can submit that, and we'll get it entered into lien. All right.
All right. Thank you, sir. Good to see you. Be well.
Thank you. You too. Take care, Mr. Geisler. On-site specialty cleaning and restoration versus Michael Joseph Smith, 251516.
Mike has the mask on.
Everybody's name, please.
And it's home.
Cameron from On-Site Specialty Cleaning and Restoration.
Cameron who?
Kessler.
And your name, sir?
Michael Smith.
Are you in your house?
Why do you have
Yes, sir.
Do you really need that mask on? I just want to make sure I can hear you.
Yes, sir. I'm missing a front tooth, and when I speak, sometimes spit comes out, sir.
Okay, you're fine.
All right, thank
so
you.
it looks like we adjourned the discovery subpoena, the creditor's exam, until today, and you were to pay $2,000 on the next day. Did he do that, Mr. Kessler?
No, he did not.
Oh, yes, I did. Yeah, the very next day, I absolutely did.
Oh, I thought you were talking about paying it today. Yeah, he did pay the $2,000 after the last subpoena hearing.
Right. So how are you going to pay the rest of this, sir?
Yes, Your Honor. I had planned on having the money, the $2,000 today. The beginning of last month, my bank accounts got froze by the state of Michigan, Health and Human Services. I got that all straightened out, Your Honor. I owed $6,000 in back child support, so I paid 1/4 of that in good faith and worked out a payment program with them. So that's where $1,500 went last month. I do have $500.
Let's slow down.
Yes, sir.
Maybe I didn't write the notes down. Was there any agreement besides him paying $2,000 on March the 18th? Which you're telling me he paid, Mr. Kessler?
Yes, he paid that.
Yeah, I know. But was there any other agreement on payment of the balance?
Yes.
Mr. Kessler, can you tell me what the agreement was?
Yeah, from the last subpoena hearing, he was to pay the $2,000 on June 1st.
That's
Wait
today.
A minute. He paid $2,000 on March the 18th, right?
Correct.
Was there an agreement that he also paid $2,000 by June 1st?
Yes.
And you're telling me you didn't pay it because the bank accounts were frozen?
No, I was saving up for it. I had $1,500 saved up. I was just waiting for my VA disability to hit this month to make the complete $2,000. And after court today, sir, I was going to bring him the other $2,000 check. It wasn't going to be an issue, Your Honor. I'm only asking. I can give him the other 500 out of the 2,000 because I have that from this month. I just need a couple other months to get back to that other 1,500 to give him, Your Honor. Unfortunately, what had happened with child support happened, and there was nothing I can do. I had to pay it, Your Honor.
Do you want to go forth with this creditor's exam, Mr. Kessler? What do you want to do? How are you supporting yourself, Mr. Smith? Remind me.
It's just my 100% VA disability, Your Honor. It's $46.62 a month, give or take about $40 or $60, Your Honor. Sometimes my insurance comes out of that. It's like $40 a month.
Well, what do you want to do? Tell me how much you can afford to pay.
I can give him $500 in good faith right now, and if he wants to, Your Honor, for the next 3 months after this, July, August, September, I can give him $500 at the beginning of every month to make this good, or he can just wait until September, and I can give him that other $1,500 plus this $500 today, if that's what they want, to make the $2,000, Your Honor. I just need a little bit more time. Unfortunately, it just happened, and I don't work.
Would you stop rambling, please, Mr. Smith? Just give me a second, will you, please?
Oh, yeah, absolutely, Your Honor.
Look, the judgment was for $58.9801. If you paid $2,000, that leaves a balance of $38.9801. Am I right or wrong?
Yes, Your Honor, you're correct.
Well, then you keep acting like 2,000 is going to end it. And I don't understand how 2,000 is going to end it. You still owe $3,898.01.
Yes, Your Honor. And talking prior to the original $2,000, they had worked something out because they know my situation that they would waive the $1,700 in good faith, and I appreciate that completely.
Wait a minute, slow down. Did you guys make me aware of this reduction?
I don't believe that we ever agreed to that.
Hey, Mr. Smith.
I apologize.
Was it on the record? Was it on the record? Did somebody say on the record from On-Site Specialty Cleaning and Restoration, whether it be Mr. Kessler or otherwise, I'm going to waive $1,700 if you pay these as agreed upon? Was that ever placed on the record?
Not in the courtroom, no, Your Honor.
Well, then it doesn't count. Okay. Unless you have a writing, it doesn't count. And by the way, you breached any agreement that would entitle you to a reduction of the balance. So let's figure this out. You guys can come up with a payment plan, but you don't get a reduction in this debt. You don't get a reduction. I don't care why your money was frozen. Who took what out of your account? I don't care why. So the only issue here is, do you want to go forth with the creditor's exam, Mr. Kessler? If you do, I'm putting you in a separate breakout room. I'm going to swear in Mr. Smith. Or you guys can enter into a monthly installment payment plan.
Yeah, we're open to that monthly installment payment plan.
Well, you guys want to work one out? Listen, I got a lot of cases going here. I'm going to put you in a breakout room. I'm going to let you two talk. I expect you two to be professional about it, and you can agree on something. In the meantime, Jennifer, maybe you can print out an installment payment order for me and send it down, and I'll fill it in, assuming they reach an agreement, okay? So that's what we'll do. You guys go into a breakout room. We'll call you very shortly. Thank you.
Yes, Your Honor.
Thank you.
Michael Anthony Harris, 5T6461588, and B. Your name?
Michael Anthony Harris, sir.
Okay, so do you have your $200 today?
Yes, sir.
Okay.
I came to talk to you about I didn't want to ever disrespect your time, and your time.
You're fine.
And I would like to know, since we're in this situation right now to speak to you, anyway, we can, lower the payment a little bit so I can get paid the whole thing. I get my license, because if I don't have my license.
How much you can't, are you asking me to not pay the 200 today?
No, I pay it right now, sir. I pay that right now. I'm saying, can we, any way possible, lower the whole balance? Because over that, because I need my license. I would like to obtain my license so I can drive to work. And I don't want.
Hang on a second.
I want to, sir.
Hang on. I reduced your balance by $13 on this case that you're going to pay $200 on today. I reduced the balance to $330 from, did I say $330 including the is Heather out there? Heather, did I say?
I am Judge. Let me look it up, and I'm sorry, I missed his name. What was his last name?
Michael Harris. He was in front of me Friday on the B file.
Okay, let me take a look. On the B file, you want to know which? It was $330 including the clearance
and how much
fee.
did he owe not including the clearance fee? I believe he owed $317 plus the clearance fee of $45 for $352.
So
right?
it would. So it's $330. That's the total is $330 with the clearance fee that he owes right now.
Yeah, but I cut it down by $22.
Yeah, let me take a look at what I took out.
What are you asking me to do?
I want to pay the $4. Like, can you take the one off and I can pay the 2 tickets? Can it be possible? Because wait
a minute, slow down. I don't understand. Pay the one off and you can pay the 2 tickets. I don't get what you're saying.
Well, when I had a price that said the tickets in LA when they came to my house in Los Angeles, and they said both tickets was like $300 or something like that.
No, they were not. They were $185 and $135, and you screwed up by not showing up on that idiots.
But I didn't do it intentionally, sir. If I'm your presence today.
Do you have another $250 with you today?
Yes, sir.
Plus the 200?
No.
I'm not going to cut it down. You're asking me to do too much here.
$450 if I'm asking not to pay.
You have $450 now?
I said that's $450 you asking to pay right now. But I'm saying. Slow
down.
You said $200 right now, and then $250 before the $50. That we talked about.
Slow down. How much money do you have in your pocket today?
I have my debit card, sir.
Can you put $450 on your debit card?
Can we lower it down to $350, please?
Mr. Harris.
And then I'll be done with it, please, sir?
No, I can't do that. I can't do that.
Okay.
I'll tell you what I will do, okay? Because you got to pay your clearance fee, too. You pay $225 more on the no insurance for a total of $425, and I'll give you your clearance too. So I'm only going to charge you $180 on that. Okay?
Well, I'll pay you total, sir.
Pardon?
I'm going to totally I'll pay you right now.
$425, and that'll give you your clearance back. Can you do that?
Yes, sir. Can you make it $400?
No, I can't do that. You kidding me?
I'm a struggling working man like you. Like
me,
sir. I'm not here trying to hit a ball, get a base hit every day, and
yeah. Well, I just saved you about $140 or $50 between these two. Between Friday and today, so you go down the hall, waive the balance. He's going to pay $225 on the B file, including the clearance fee. Okay.
Okay, Judge.
You go to law school.
And Judge said every penny count. They told me that.
Good luck. Get out of here. Stay out of here. Good luck to you.
Get out of here.
I wish you well.
Thank you. Thank you guys for serving.
Have a good day. Midland Credit versus Robert Rupert. 2-4.
Your Honor, if we could pass that one for just a moment. The
sure.
Plaintiff's attorney's in with another person.
How about LVNV versus Zakaria?
I believe.
Good morning, Your Honor.
Let me-
Preston Nate appearing for LVNV.
I need you to start your video. LVNV funding versus Christopher Zakaria, 2600626. Morning, Mr. Nate. How are you? Your appearance?
Good, Your Honor. Thank you. Preston Nate, P77884, appearing for LVNV.
Is Ms. Palon here?
Your Honor, she has not appeared and we have left a message at her office.
Mr. Nate, how long you been practicing?
10 years in this field now.
Maybe you can make me understand why we got to track down lawyers. Can somebody, maybe any of the other lawyers can tell me too, but I'm getting a bit tired of it. We shouldn't have, no judges called my office when I was practicing 35, 40 years ago. I don't ever remember them calling me up and saying, hey, where are you? Or their staff. I mean, this is crazy. What do you want me to do here? I'm not going to chase them down, and I'm not going to set a pretrial date without them, and I'm not inclined to reschedule anymore. I'm just getting tired of this.
Well, I mean, we work with Jenny quite a bit. I don't know where she's at today.
Call her up, and get her to come in here, and we'll go from there. I don't relish in entering defaults, but why should the staff just have to reschedule? Or why shouldn't she have to show up? That's the way I feel about it. So will you please try to get a hold of her, and I'll go from there?
Yeah, I can give her a call.
Thanks.
See if I can get a hold of her.
Jefferson Capital versus Ellen Stone, 2601149.
Good morning, Your Honor. Ellen Stone here.
Good morning, Ms. Stone. How are you?
Good, sir. How are you?
Good.
Sorry, I was on mute. Jay Begg on behalf of plaintiff.
How you doing, Mr. Begg? All
Good.
right.
Yourself, Judge?
Good, thanks. So what do we got here? Did you two try to work this out?
We've got to jump, Judge. That's what we've got to do.
I'm just wondering.
Hold out for a second. Josh has found something for us, so give us just a second to find our way there. Hang on.
You are banished from the state of Georgia.
Okay, hold on. We're going to start at the very beginning of this one. And let's go back. Travis County. We're in Texas for this one. Going in blind, but I trust Josh with my viewing decisions. So.
Okay. We are now live on YouTube. Judge Sylvia Holmes will begin shortly. Thank you.
You know we love Travis County, right? I just missed it, Kaz. I'm so sorry. Justice Holmes, if I remember correctly, if this is the right one, there was one day where she just dismissed everything. Like all the cases that were brought in, she just dismissed them all. She's like, nope, you did it wrong. Dismiss. It was hilarious.
Good afternoon, everyone. I'm Judge Holmes. If you would, please give me a thumbs up so I know that my audio is coming through clearly for everyone. All right, looking good. Seeing responses. Thank y'all for being here. Well, this afternoon we are here for 8026000004, Miss State of Texas versus Scott Barber. On behalf of the State of Texas.
Good afternoon, Judge Rachel Rogers, on behalf of the plaintiff, the State of Texas, along with one of our secretaries from the office, Ms. Borrego.
Good afternoon, Ms. Rogers and Ms. Borrego. Welcome to both of you.
Very sing-song voice for the
We have
judge.
someone here on behalf of the defendant, Scott Barber.
Yeah.
Mr. Barber, I see someone waving. You'll need to unmute.
Got the whole
Good afternoon.
Van Damme in there.
There are two people at least I can see in the camera. Which of you is Scott Barber?
Scott's here. The older gentleman.
Sir, are you Mr. Barber?
Yeah,
Okay, you're Scott Barber. And
my hearing is not so good, so I'm reading my phone.
that's not a problem, sir. And who do you have with you today?
Got my whole family here.
Who do I have what?
Who is the gentleman next to you, Mr. Barber?
My son, Landon,
Good afternoon to you both.
and my wife, Casey, Kathleen.
Good afternoon. Hello.
Hey, family.
All right. Ms. Rogers, please tell me why we're here.
Thank you, Judge. Brief overview or the style of the case?
Style of the case. Which section are we at?
Well, we're looking at a serious bodily injury case, dog bite case, and we have the defendant, Mr. Scott Barber, here over a dog named Shadow. Mr. Denning is also present on this call. He was the victim in this dog bite case that happened in April. And when the court's ready, I'm happy to give a very brief overview.
I love your robot doll, by the way. Joy W. Yes.
Go ahead, Ms. Rogers. Thank you.
As soon as this
Thank
is
you,
done,
Judge.
we'll go back to that.
A little after 8 a.m. on April 27th of this year, Mr. Thomas Denning, who goes by Tom, took a walk with his wife Charlene in their neighborhood, which is located in Travis County. During this walk, they passed Mr. Scott Barber and his dog Shadow. Mr. Denning said good morning to Mr. Barber, and out of nowhere, the dog Shadow attacked Mr. Denning from behind.
The
Shadow wrapped his front paws around Mr. Denning's body, scratched his legs badly, and bit a chunk out of Mr. Denning's hand, severing tendons and exposing them, also leaving a gaping hole, which required stitches. Shadow was able to do this while on a leash. Shadow attempted a second attack, but was restrained this time. Mr. Denning was bleeding badly, so his wife ran back to their home to get towels and call for help. Mr. Denning received emergency care at Baylor Scott and White and continued with follow-up hand specialist care, which to this day remains ongoing. Mr. Denning was told that Shadow was up to date with vaccinations, but during the course of this investigation, you'll hear that veterinary vaccination records have not been provided, and that in conversations with officers, it was conveyed that the dog does not receive regular checkups at a vet, nor does the dog wear a rabies tag vaccination. And the last known rabies vaccination was at the time of the adoption 5 or 6 years ago. Because of the severity of the attack, the fact this happened in a community, this happened in a neighborhood, and by all admissions, this dog is exposed to children, neighbors, and this was an unprovoked attack. And under Section 822 of the Health and Safety Code, we do not believe any exceptions apply, and we are asking the court to order humane euthanasia in this case.
What type of treatment did Mr. Denning receive?
He went to the emergency room, received emergency care. They did wait to respond to TCSO and then went directly to Baylor Scott and White. He's also under the care of an orthopedic surgeon who is a hand specialist specifically. And due to the fact some of the tendons were severed, this is an ongoing situation. And I'm hoping that he in time regains full mobility, but that is certainly not anything that has been promised, stated, or implied in any way. At this point, we're looking at a very serious injury that is ongoing.
All right. I think I'd like Ms. Rogers, if you would, ask us a few questions of the victim. What is the ongoing state? What are the recommendations from the doctor?
I'd be happy to just briefly ask some questions of our victim, Judge. Thank you. Mr. Denning, can you hear me?
Mr. Denning, I'm going to swear you in very quickly. Will you raise your right hand, sir? Do you understand by appearing in court and offering me testimony, you swear to tell the truth, the whole truth, nothing but the truth under a penalty of perjury? Do you so swear?
I do.
Fantastic. All right, go ahead, Ms. Rogers.
Thank you, Judge. Mr. Denning, can you please state your name for the record?
Thomas Denning.
And is the address where this occurred in Travis County?
Yes.
Okay, could you please walk us through briefly kind of what happened with this incident?
Yeah, well, it was just a typical everyday morning. 5 weeks ago today, My wife and I take a walk every morning. We're fairly new to the neighborhood. We moved in 2 months prior to the incident. And, you know, on a typical walk, we'll see neighbors with their dogs, and we don't think much of it. We've been dog owners ourselves in the past. And typically, I get to know my neighbors, oftentimes through their dogs. And this morning, we were walking up the hill. It's got a pretty steep hill, and we're walking up the hill, and I saw Mr. Barber coming down with his husky. The husky seemed well behaved. He was walking along the curb, so I didn't think anything of it. He happened to be on the same side of the street as us. We were always facing traffic. He was walking on the same side. The dog didn't seem to have any kind of, irritation or any agitation or anything. So we were walking up the hill, and we got closer. I didn't want anything to do because the dog is large. I didn't want to. It looked like it might have puppy characteristics about it and want to play, and I didn't want anything to do with it. So I made a kind of a wide berth around, said good morning to Mr. Barber, and figured that we were on our way. And all of a sudden, the dog out of nowhere wrapped his front paws around my waist, and I realized that this was not a friendly, kind of playful kind of situation. So I responded by moving my arms out, and he latched onto my hand pretty hard, and immediately I was shocked and stunned by the situation, and I was bleeding profusely out of my hand, and I kind of started swearing at Mr. Barber, and it's like, control your animal, and then the dog got agitated and came at me a second time, but now head on, but he was able to restrain it because the dog was on a leash. And then, I'm looking at the wound. I'm kind of in shock. The dog has now been restrained. I began to walk back home. I was about 100, 150 yards from my house. And, I was bleeding the whole way down. And Mr. Barber continued walking behind us. And I asked my wife to run ahead and get a towel to see if I could stop the bleeding. And I wanted to kind of observe where he lived because I didn't know Mr. Barber, and I wanted to see whether or not, we could follow up with this situation. And he put the dog away. I could see he was like 4 doors down from me. He put the dog in the house, and he was
Mr. Dunning,
to come
give
down.
me 1 second. I think we lost the judge. Give me 1 second.
She gone. She gone. She comes back. What is it, Josh? Should we fast forward, or is she accidentally clicked hang up? I don't want to see like gruesome hand pictures, but I would like to know which hand it was. And Red Bull in court gives you wings. Not a sponsor. Do we need the judge? Josh says fast forward. Okay, hold tight. Let's see how far we need to fast forward. Just till the judge shows back up again. She comes back in after about a minute. Here we go. Just waiting patiently for the judge. There she is. She'll just appear like normal. Watch. Ready, set. Oh, she beamed in.
My apologies, everyone. That was a fun moment.
She beamed in. Did you see
Ms.
that?
Rogers, Mr. Dennick, I apologize, especially since you were in the middle of what is, probably non-pleasant testimony to recall. When my computer decided to go a little bit haywire on me, you had taken a wide berth around the dog.
Right. We just greeted Mr. Barber, and then the dog, very unexpected to me, attacked me from behind, basically jumped up on my back, wrapped his front paws around my body, and then was, coming down my body, scratched my legs. And as I was trying to ward the dog away from me, he latched onto my hand and gave me a pretty good
Can dogs give hugs
hand
like that?
wound.
They don't have elbows like that.
That began to bleed immediately, profusely. I got agitated, as you can imagine. I was shocked and surprised. I used some colorful language and was kind of yelling at Mr. Barber to control your animal. And then the dog made a second run at me from head on, and he was able to restrain him. But, you know, it was a big dog, and Mr. Barber, he's not, you know, he's not a spry, youthful guy. The dog was, you know, he had some trouble restraining the animal on the second lunge, but I could tell that he had control. So at that point, I just started heading home. I was about 100, 150 yards from my home, and I knew I had to take care of my wound. And so I was bleeding the whole way home. There's a trail of blood from the incident all the way to my house. But at the same time, I wanted to see where Mr. Barber lived because he was walking in the same direction as my house. And so I asked my wife to run ahead and get a towel so I could stand in the driveway and kind of get a sense of where he lived because I'd never seen him before, nor the dog. And I saw that he lived about 4 doors down from me, 3 or 4 doors down from me, and he put the animal away. And Mr. Barber, you know, was kind enough to walk down and see how I was, and we chatted for a little bit, and it was obvious that I was going to need some stitches, and he said, well, I'll help pay for the stitches and things like that, you know, nice pleasantries. And then we exchanged the name. He gave me his name and telephone number. And then I went inside into the house, and I had the wound, you know, in the towel, and I Googled what do you do when you get, you know, when you're under a dog attack, what's the next thing to do? And you basically call the sheriff. So I called the sheriff, and they came out, I'd say within 15, 20 minutes. The sheriff was a decent chap. He came in, he seemed a little cavalier about the whole situation. He indicated to me immediately that he was a dog owner and a dog lover, and he kind of minimized my injury. So we knew it was something that required stitches, so we went to the emergency room, and they immediately, you know, they couldn't really believe because they heard it was a dog bite, but then when they saw the size of my wound, they realized it wasn't just a standard kind of a dog bite, you know, with a puncture wound. This was a real slashing kind of a wound. And in fact, it had, you could see the tendons had been cut, had been severed. And so the emergency room doc realized that it was going to require more than he could do. So Dr. Cass Stevens, who's a orthopedic surgeon specializing in hand wounds, was on staff, but he wasn't available to come and treat me. So the guy said, okay. He washed and cleaned the wound tremendously because it can be really one of the things that can, I guess, be the worst outcome of a bite like that is infection, right? So he washed and washed and washed the wound, sealed it up with stitches. He sent me home. I had an appointment with Dr. Cass Stevens the next day. We ran through a bunch of diagnostics on my dexterity and my hand and so on. And he realized that there was going to be some probably permanent limitations to my dexterity, but not severe. I can still grip, for example, but some of my lateral motion of opening my hand and closing my hand is going to be probably permanent. And then he said to me, look, you know, I'm 69 years old. He said, that, you know, it's like, is it worth the surgery at this point and risking the infection, or should we just go ahead and live with it? And I said, well, I can probably live with it. That's what I'm going to try to do. So I had a follow-up meeting with him. The wound is healing up nicely. And we have one more follow-up coming up in I think, a week or so.
Okay, a couple questions, Judge, if I may.
Please do.
Thank you. Okay, so you're continuing follow-up care, is that correct?
Correct.
Okay, and were you prescribed antibiotics as a result of this?
I was.
Okay. And are there any future dates you have on the calendar to follow up with Dr.
I do, but I
Stevens?
don't have it in front of me.
Okay,
right now,
that's fine.
It's within the next 2 weeks.
Okay. Judge, with your permission, we would like to show some exhibits that have been previously marked. Would that be all right with the court if we provide some photos?
Absolutely, Ms. Rogers.
Thank
We can let you share them directly. I'll always caveat, always a cautionary tale. When you hit share, sure you know what you're sharing because it will share everything. You know, if you've got eBay or you're looking at something on your browser.
Yeah.
I don't have anything like that on my browser.
Right.
May I ask that Ms. Borrego, who's one of the paralegals in our office, share?
She's like,
Thank
wait,
you.
I've got stuff on
We're
my
happy
browser.
to give you that permission. Just be aware of what's open when you hit share.
We're all going to be
Ms.
watching.
Borrego, if you could open Plaintiff's Exhibit 1.
It's a no judgment zone.
And Judge, all of these exhibits have been previously provided to the court and to Mr. Barber in addition. Mr. Dunning, are you able to view this picture?
Oh, he bled on his shoe.
Yes.
The ballet shoes?
Do you recognize the individual in this picture?
Yeah, it's me.
Okay. Do you see an injury to your hand, blood on your leg, then blood on your shoes?
Yes.
Is this a true and accurate copy of the picture from the day of the incident?
Yes, it is.
With the Band-Aid
Judge,
on it?
we'd move to admit plaintiff's exhibit 1.
Is this before or after treatment with the hospital?
This is before.
Okay.
This was the at-home triage, correct, Mr. Denning?
That's
Mr.
correct.
Barber, do you have any objections to the photos that plaintiff is going to be showing me or that the state is producing?
Paging, Mr. Barber.
Mr. Barber, do you have any objection to these photos being accurate photos taken by the witness?
No.
Okay, so I admit it, Ms. Rogers. We can go to the next one.
Thank you. Ms. Borrego, would you please pull up plaintiff's exhibit 2? Mr. Denning, do you recognize this photo?
Yes.
Ouch.
Is this the underside of the hand that was bitten by Shadow?
That's correct.
And is it a true and accurate copy of the photographic evidence taken of your hand during that day?
Yes.
Judge, we'd move to admit plaintiff's exhibit 2.
All right, is this a copy? Mr. Denning, were you bitten on your left hand?
Yes.
So admitted.
The phone was there for privacy reasons.
Thank you. Let's pull up plaintiff's exhibit 3, please, Sally.
Okay.
I apologize. This is where it gets graphic. Mr. Denning, do you recognize the hand and injury in this photo?
Ouch.
Yes.
Is this a true and accurate copy of and representation of your hand at the time you were being seen in the emergency room at Baylor Scott and White on April 27th?
It is.
Judge, we'd move to admit plaintiff's exhibit 3.
Mm-hmm. Is that incision or is that wound? Is that between your pinky and your ring finger?
That's correct.
Okay. So admitted.
Oh, I've never seen inside a hand
We'd
before
like to
like
view plaintiff's exhibit 4, please.
that. Come on, guys.
Mr.
Come
Denning,
on.
do you recognize the hand in this photo?
Yes.
And is this a true and accurate representation of your hand at the time that the bite incident occurred?
There we go. Yes. We're going to just put it over
Is
there.
that a tendon that's visible in the middle of the injury?
It is.
Judge, we'd move to admit plaintiff's exhibit 4.
Admitted.
Are we getting any
Then
closer?
we'd like to view plaintiff's exhibit 5, please.
Oh, wait, this is a good one.
Mr. Denning, do you recognize the leg and feet in this picture?
I do.
Is this a true and accurate representation of your legs post-injury being seen at Baylor Scott and White?
Correct.
Thank
Objection.
you. We'd move to admit plaintiff's
relevance.
exhibit 5.
So admitted.
You bled on them. That's
Then
all.
we'll like to view plaintiff's exhibit 6, please. Mr. Denning, do you recognize this to be Shadow, the dog owned by Mr. Scott Barber and the dog that bit your hand on April 27th of this year?
Looks similar.
Well, all huskies look
We
similar.
need to know for certainty, do you recognize this to be the dog that bit you this year?
Well, yes.
Okay. Thank you, Judge. We'd move to admit plaintiff's exhibit 6.
Mr. Barber, is this a photo of your dog? It went up here.
Right.
Mr. Barber, was that a photo of your dog, Shadow?
Yes.
Okay, so admitted.
Thank you, Judge. Now, was it your understanding, Mr. Denning, that the dog Shadow was up to date on its vaccinations?
Yeah, when Mr. Barber came down the hill to chat with us after the wound, we did ask him whether the dog was up to date on rabies vaccination. My wife, in fact, asked that question very specifically, and he indicated that he was.
Have you been provided a copy of any vet records or proof of vaccinations for the dog Shadow? Could you answer audibly, please?
No, I have not.
Okay. Thank you. And have you had any additional interactions with Mr. Barber or
Shadow?
The dog Shadow?
None.
Okay. And have they paid for the medical bills?
No.
Okay. Judge, we'd pass this witness.
What? Mr. Barber, do you have any questions for Mr. Dunning?
Is it okay if I speak mainly for him and he says yes, mainly? Or if this
Can I refute one thing?
Certainly, Mr. Barber, I'll say you absolutely are going to get a chance to refute things and to present your information. Right now, though, we have a witness. So do you specifically have any questions for Mr. Junig, either about what he said, or if you have any specific questions you'd like him to answer, maybe things that he did not tell us?
Okay.
Do you? That's a...
Yes, one thing is that I never discuss any rabies with anybody other than the sheriff.
Okay.
Shots.
Do you have any questions for Mr. Junig?
Any questions?
For the witness. All right, how about Mr. Barber, your son? Did you have any questions for the witness?
When Shadow was approaching you, like with his behavior, when he does this, I've owned him for 5 years. He does he does sometimes become jumpy. Did you push his face? Did you push him when he was doing that? Exactly?
But he came up from behind me, so I wasn't pushing anything. He came up from behind me and grabbed me, and he was scratching my legs.
Was he appearing aggressive? Did he bark at you beforehand?
There was growling.
Okay. So when there was a space, was there an actual amount of space you were able to go to in the street? Like the other half? Like not in between, 3 feet of the person. And did you see how long the leash was?
Judge, I'm gonna have to object here. This is asked and answered. My Mr. Denning has already stated his back was to both Mr. Barber and the dog at the time. In addition, it would call for speculation about whether there was space behind him to go somewhere. I think this is a bit far-reaching, so I'm going to object.
Mr. Barber, what's the question you're trying to reach? So he said he was attacked from behind.
Can I give my statement? Is there time for that?
Mr. Barber, you're going to get a chance to respond, but first the state has to meet a burden of proof. So this is them establishing that a dog attack occurred, that someone was injured, and that injury was severe enough that it would warrant the dog being put down. So this is their part of the case. You, as the person defending, always get a chance to ask questions of the witness. That's cross-exam. When the state says, Judge, that's it, I've got no more witnesses and no more evidence, then you get all the time you want to be able to defend the situation. But right now, we're in cross-exam, so you're limited to just questions to Mr. Dunning. So do you have any other questions for the witness?
I'm just no saying as specifically as how you had much space to move to the right side of the when you encountered seeing Scott and the dog. Like you had much space to move to the other side of the road and had much 100 feet around there.
Mr. Barber, that's not a question. So what is the question you're asking him? You're trying to lead him somewhere, but I don't know where you're leading him.
I'm just saying is just how, did you have enough time to give Scott enough?
Escape from the dog attacking you?
No,
it's not. Is that the question you're putting to him? Is there enough room that you could have avoided the dog lunging for you from behind?
It wasn't behind. It wasn't a thing like that.
I'm going to object testimony.
Ms. Rogers. Mr. Barber, were you present at the time of the incident?
Currently not an eyewitness, sadly. But
okay.
I was...
Then you would not be able to testify to that. Do you have any other questions for the victim?
Sorry.
Not you, Ms. Rogers. It's still defendant's turn. Mr. Barber, do you or your son have any other questions for Mr. Dunning? Mr.
No.
Barber, anything further?
No. No.
Okay. All right, Ms. Rogers, anything further for the witness?
Nothing further from Mr. Denning. We'd like to call our next witness, Officer Elena Grove.
All right. Good afternoon, Officer Grove.
Good afternoon, Judge.
Will you please raise your right hand, state your name for the court?
Elena Grove.
You understand that by appearing in court and offering testimony, you swear to tell the truth, the whole truth, nothing but the truth under a penalty of perjury. Do you so swear?
I do.
Go
I
ahead.
do.
Go ahead, Ms. Rogers.
Thank you, Judge. Officer Grove, could you please state your job title and for whom you're employed for the record?
Yes, I am the lead serious bodily injury investigator for Travis County and the city of Austin.
Thank you. And so are you the animal services officer who responds to serious dog bite injuries?
That is correct.
Okay. And how many cases roughly of serious bodily injury dog bite cases have you been a part of?
Hundreds, if not thousands at this point.
Understood. So how was your attention brought to this situation at hand?
Yes, this case was sent to our department by the Travis County Sheriff's Office, and then our dispatch forward sent this case to me due to the severity of the injury.
Okay. And during your investigations, was there any evidence that you reviewed?
Yes, I collected.
So this is not getting any better.
Medical records, before and after medical photos of the injuries, and then went forward to write an affidavit for seizure and a warrant due to the incident.
Okay.
It's not getting
And
any
did
better.
you have an
And I'm going to
opportunity
jump.
to meet with both Mr. Barber, the owner of the dog Shadow, and Mr.
We're gonna jump. It's not getting any better, and it doesn't look good for the dog right now. And I'm not here for that. If anyone wants to watch that, that is on YouTube. That is Justice of the Peace, Travis County. Is the YouTube channel that's live right now with that hearing. How does it end? Not good for the dog. Look, it sounds like the dog that was the last person it gets to bite. So. State 1, doggy 0. I'm guessing there's probably some medical bills that need to be paid by the family to the victim as well. So, all right, yeah, bad situation. Don't let your dog get in that situation, people. All right, while we're waiting for court to come back, currently we are staring at the wall, and we don't want to do that. So, see if we have another case. I think I had just gotten to the part in Judge Dad's hearing. I think that was the one we were supposed to watch. See if we can go back there and catch the rest of it. Just one second. Judge Dad, where are you at? Can't remember his name. Judge what? What's his last name? Give me Judge Dad's name.
Banished from the state of Georgia.
That was a soul-crushing interlude. McNally, there it is. Judge McNally. Judgment Valley. That's close. I said Judge McNally. Judge Michael McNally. There he is, right here. Let's go back to where we were there on this one.
How you doing, Mr. Begg? All right.
Good, yourself, Judge?
Good, thanks. So what do we got here? Did you two try to work this out?
I'm just wondering, is this up also for a motion to compel arbitration, or are we just doing the pretrial?
Just the pretrial.
Yes, Your Honor, she filed a motion to for arbitration on May 20th. It wasn't enough time to put it on today, so we scheduled that for July 13th.
Oh, I see. I see her answering affirmative defenses. Well, I'm just going to set dates, okay?
Yes,
I'm
sir.
just going to
That's fine.
set dates. All right, give me a second here, if you would, please.
Slav Life, best of luck to you and your pup. Hope for the best there.
All right. Let's see. All right, today is June the 1st. Discovery is to be completed by August the 1st. No ADR. No motions will be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury, correct?
No, Your Honor, but I am compelling motion for arbitration. It is in the agreement, and that's. Go ahead. I'm sorry, sir.
Why did we set it all the way on July 13th, Jen?
I came in person and paid.
Hang on one second. I'm talking to the judicial clerk.
Oh, sorry.
Or the
Judge, I think just the 15th.
The 15th.
No, I don't know, Judge, why we went all the way to July.
Well, let's not. Okay.
You want to move it up?
Yeah, we're gonna have that hearing very shortly, but I'll talk to you about that.
I can move it up to June 15th.
Okay. We're gonna set that for June 15th. Witness lists are due July 1. Discovery cutoff is August 1. And we're going to set a trial date for the 3rd week of August, which would be what, Jen? 4th week.
Your Honor, I object to that. I want to move this according to the agreement in the contract.
Ms. Stone,
yes, sir.
I'm just setting these dates now to make sure that if I deny your motion, we're on track. That's all.
Okay, because the attorney agreed to. He said he wouldn't object to the motion to compel arbitration.
I only said that if the motion was to be heard today.
Right.
Can we reschedule
for a motion?
Slow down. Please slow down. Look, I don't even have the motion. You didn't file it timely so it could be heard today, according to what you just told.
Yeah, and I think that was why it was set for July 13th.
Well, I'm moving it back this way. I'm moving it this way so I can hear it in a couple weeks.
Okay, I understand.
Look, maybe we'll just do this, Jennifer. What is the date you're going to have that for? June 15th, did you say, or June 13th?
June 15th at 10 a.m.
Let's do it June 15th at 10 a.m. And I will also have a pretrial that day in the event that I deny it. How's that? So the motion hearing will be set. I presume, I'm sorry, what time did you say? June 13th at what time?
June 15th at 10 a.m.
At 10 a.m. When did she file the motion?
May 20th, Your Honor.
Why couldn't we have heard it this day? That's all I'm asking. Why couldn't we have? That's plenty of notice.
Well, with the holiday, so 7 days would have been the 27th. We normally try to give them at least 10 days to respond.
Yeah.
Who to respond? I sent a notice
Ms.
to.
Stone, Ms.
Yes,
Stone,
sir.
would you just let me handle this, please?
Thank you.
Okay. You're getting a little bit too aggressive for me, okay? I'm
just nervous about it, but thank you.
I'm going to accommodate if the case deserves to be, if the case should be set, removed to arbitration, I've got no issue with that. I'd be glad to get it off my docket. I got enough to do here, okay?
Thank you, sir.
Jennifer, we're going to set this for next Monday. Is there a reason I can't do this next Monday? Mr. Baig has had the motion now for 10 days, right?
On the 8th?
June 8th.
Let me look at, I got to see what time that's. I don't have that day pulled up because it's traffic. You have a couple of landlord-tenant bench trials at 10:30, so we could add it.
Let's do it
at
at 9
10:30.
o'clock. Mr. Begg, have you looked at her motion? Let's do it at 9 o'clock. 9 o'clock on June the 8th. Mr. Begg, have you?
I looked at the motion, but I didn't see the provision where she attaches for arbitration is in such fine print. I can't read it. I'd like counsel of record to review and respond if necessary.
Well, that's what I'm doing. I'm setting it for June the 8th at 9 o'clock. We'll see everybody here by Zoom next week. And if I deny the motion, we're going to also set it for a pretrial, Jennifer, okay? All right. Thank you. I'll see you next week.
Thank
you.
Midland Credit versus Lee Bonder now.
Love that she objected to setting the date.
2601321.
Your Honor, plaintiff is in with her last case.
All right.
She's got 3 of them this morning at 8:30. So.
Did you get a hold of Ms. Palin, Mr. Nate?
No, I tried to call her office. Just got the answering machine. I emailed her as well, but I haven't heard back from her on that front either.
I think it closes around 5:30 or 6. I think the court closes that time in. Let's see.
Does Ms. Palin have a history of this with us, Jennifer?
Unfortunately, yes, Your Honor.
I'm entering a default. Go ahead and take your numbers. Default judgment will enter. She's going to have to, and please don't sign a stipend order to set it aside. She's going to have to file a motion if she wants, okay?
Okay, I will go ahead and prepare that.
Yeah, go ahead and give me your figures and we'll go from there.
Yeah, so the amounts on the judgment would be as follows. Complaint amount, $1,250.69, plus the filing fee of $55, and then the service fee of $54.16. And let me grab that number.
Are you asking for attorney fees, statutory attorney fee?
No, we usually forego the statutory attorney fee. So the total judgment is going to be $1,359.85.
Yeah, I hate to
Your
do
Honor,
this.
she just logged in.
Where is she?
I'm admitting her right now.
She's here.
Miss Palin?
You have to start your video, Ms. Palin.
Good morning.
Ms. Palin, your name?
Jennifer Palin, Kate 0284.
Well, why do we have to call you and remind you of your court dates? Why do I have to have the lawyer here, Mr. Nate, remind you? I don't want to be a tough guy about this, but I've got a docket to move to. And I don't think our staff should have to, with the overwhelming workload that we have and they have, should have to be acting as somebody's babysitter. I'm sorry.
I thought I was logging in early. I thought this hearing, I have it on my docket as 9:30.
What's at 8:30?
For Zachariah?
Yeah. That's what it
I
says on mine.
sincerely apologize. We have it as 9:30 in our system, and I will look into that.
Well, I was just taking a default from them because I'm told that you do this with us, and I don't like that, okay? I mean, we don't have time for this.
Understood.
Come on. I was just telling Mr. Nate, I practiced law for 11 years before I got here. I don't ever remember a judge's office or judge's staff calling me up and saying, hey, where are you? Not once. Not once. I get the fact you guys have volume, but what are we doing on this? This is a pre-trial? You guys want to talk, or you want me just to give you dates?
Dates is fine. We'll get this figured out. It is a pretrial today.
Here's what I'm doing.
He can get grumpy. He can yell.
All right, Mr. Nate, you're 77884, right? Ms. Palin, you're 80284?
Yes.
All right, discovery will be cut off on August the 1st. No motions will be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury. There will be no settlement conference. I'm going to put down 1/2 hour for trial. Witness lists are due July 1 of 26. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. And let's see. The trial date will be, give me a date around August 25th or something.
Judge, I'm going to need to go to September 1st. We've got 12 right now on September 20 or August 24th.
Oh, bench trials?
Yes.
12 bench
No,
trials.
they're all going to settle. August 24th at what time?
10:30?
They're all going to settle.
Okay. All right, that's what I'm going to do. And you guys can try to resolve it. If you can't, we'll see you here on that date for trial. Thank you very much. Have a good day. Sadie, here
They're not going to settle.
Thank you.
Midland Credit
Luca, I'm
versus
so
Lee
sorry to hear about
Bondernack.
that.
2601321.
Cancer is a monster.
Yes, Your Honor. Francine and James from Midland Credit.
Good morning, Ms. Jones. Ms. Bondernack, your name?
Lee Bondernack.
Did you guys talk in a breakout room, Ms. James?
Yes, we did, Your Honor.
Any resolution?
Yes, Your Honor.
Okay.
So what we agreed to, Ms. Bondernack has already been paying. She's paid 2 payments already towards the debt for $80. And so she has a remaining payment, 5 payments that she needs to pay monthly for $80 and 1 remaining payment.
I need to know what the balance now is. What is the balance now?
The balance right now is $473.70.
So is that what we're going to enter a judgment for?
Yes, Your Honor.
Okay, for $473.70, it's going to be in the form of a consent judgment. Is that right?
Yes, Your Honor.
And she's going to pay how much? How often?
She's going to have 5 payments of $80 per month.
No, it's every 2 weeks.
Oh, every 2 weeks.
$80 bi-weekly beginning?
My next payment is on 6/12, June 12th.
So is that the agreement that you guys are going to submit a consent judgment with the total amount of $473.70, and it's going to have an installment payment provision which provides for the defendant to pay $80 biweekly beginning June 12th of 26 until paid in full? Is that right, Ms. James?
Yes, Your Honor. The last payment will be a little less than $80.
That's fine. Does Ms. Bondernack, does Ms. James have your permission to sign your name to this proposed consent judgment?
She does have my permission, sir.
All right, so she's going to enter that. You stay in accordance with those payments. They won't be able to garnish wages. You should have it paid off then in what, about 10 weeks, a little bit more. Okay? So
yes, sir.
I wish you well.
Your
Anything
Honor,
else?
Your Honor, I wanted to ask for her email address before we hang up.
Can you give her your email address, Ms. Bondernack?
It's my first and last name.
Yeah, we don't need your email address though. We really don't need that. So yeah.
Okay, thank you, Ms. Bondernack.
You're welcome, Ms. James.
That's it. You guys are all set. Anything else, Ms. James?
No, Your Honor.
It's really bad when the judge has to call you and remind you to come to court.
Ms. Bondernack?
Especially if you're a lawyer.
Have a great day, you guys. Thank you.
Thank you. You too.
All right. Midland Credit versus Angela Sladich, 2601407.
Francina James for Midland Credit, Your Honor.
Angela Sladich here?
Your Honor, she is. She didn't come out of the breakout room. Oh, she's out now.
Ma'am, can you start your video? Angela Sladich, start your video and unmute, please. You have to start your video.
Okay. There we go. Can you see me?
And your name?
Angela Sladich.
All right. Good morning to you. Did you two talk, Ms. James?
Yes, we did, Your Honor.
Any resolution?
Yes, Your Honor. Go ahead.
No, that's it. Go ahead and provide me with the terms.
Okay, so Mrs. Angela is going to pay a total of $529.79, and we're going to do this by consent judgment. She plans to pay it. Well, we didn't get a date when she plans to pay it. But I did get her email address, and she did say that we would sign on her behalf.
When can you pay this, Ms. Sladich?
I told her on or before 6/30/26, so before the end of the month it will be paid.
Okay.
Yes.
And that's acceptable to you, Ms. James?
Yes, Your Honor.
And ma'am, does Ms.
Yes.
James have your permissions to sign your name to this proposed consent judgment?
Yes.
All right. Any questions, either one of you?
Nope, I am all set, sir.
So you just need to pay it on or before June 30, and you're all set. She's going to sign your name. They'll send it over here. I'll sign the order, and you'll be good to go. Thank you very much. Good luck to both of you. Thank you.
Thanks so much. You have a good day.
You too.
Bye-bye.
Nice to see somebody smiling, Miss Ladich. And Miss James,
what else can you do?
All right. Do I have the parties ready on onsite versus Smith?
Thank you.
Judge, they're in a breakout room still.
That's fine.
But Miss James is here on Rupert. We
On
passed
which
that
one?
one because Rupert is.
Oh, yeah.
Robert
Midland
Rupert.
Credit versus Robert Rupert, 2504832. Your appearance again?
Francina James for Midland Credit, Your Honor.
Mr. Rupert, your name, sir?
Robert Rupert.
Good morning to you.
Good morning.
Did you two resolve this one?
So, Your Honor, we did not. The defendant needs more information because he doesn't necessarily acknowledge the debt. He thinks it may be his brother may have took the card out in his name. And so what we ask for is to do 60 days for discovery.
Okay. Wow, has he done that to you before?
Yeah, I'm 60, gonna be 62, and I've been through court systems over my brother for 30 years in and out. Not on a regular basis, not real recently, but yeah, it's been a real mess. And it's what's even worse is our names are just reversed. I'm Robert William and he's William Robert, and it's just been a mess, Your Honor.
All right, this is what I'm going to do. I'm going to give you until June the 30th to file your witness list. Actually, July 1, we're going to make it.
One of you has to change your names too.
Nobody demanded a jury. No, we're not going to have a settlement conference or ADR. Witness lists are due by July 1. Discovery cutoff is August 1. We're going to set that same trial date of August the 24th at 10:30. And you do not have to file a trial brief, but if you choose to, you have to file and exchange it not later than 7 days before the trial. And we will go from there. I'll send out this order. Again, no motions on the date of trial. All motions for summary have to be filed and heard, again, not later than 20 days before the trial date. Okay? So we're going to send this out. You'll have it in the next few days. Mr. Rupert, if they have something that you want, you make that request, okay?
Okay, do I just make it directly to them?
I imagine it's easier than
this is
picking
all
new
new to me.
names.
I apologize for not, being.
Sure, Sadie. The discovery is the exchange of information. You could send requests for production of documents.
Okay.
And you could ask them to send you all accounts with your signature on it. You could ask them to send all statements of activity. Remind me, this was a credit card, right? Right, Ms. James?
Yes, Your Honor.
Anything you want, you can request in writing from them, and they have to provide it to you. And if they don't, then you can file a motion to compel them to do that.
Okay. Thank you, Your Honor. Yep, I appreciate that information.
It's not, I don't have enough time to give you the whole process here, okay? But maybe you can talk to a lawyer. If you think, you ask them for whatever they might have that can help you show that this was a fraud. Card opened up by your brother or somebody else, okay?
Okay.
I wish you well. Good luck. Thank you.
All right, thank you. You have a good day.
You too.
Thank you, Your Honor.
Thank you. Do I have Meadowlands versus Jones? This
Good
is
morning.
2601076.
I'm done, right?
Brianna Kingsley appearing on behalf of the plaintiff, Your Honor.
So do I have somebody here for Mr. Jones? I'm a little concerned about this.
So yes, Mr. Jones has a Guardian Care Inc. Mr. Wisniewski was logged in earlier. He sent me an email. I've been in communication with him about this matter for the last few weeks. He sent me an email earlier. He has a circuit court matter that he had to attend to. He indicated he doesn't oppose the motion though. Like I said, I have been in communication with him. So this is plaintiff's motion to have the mobile home removed from the property. The home is in an extremely dilapidated condition. Previously, Gibraltar Township Ordinance was out there to inspect the home prior to Mr. Jones being removed to a long-term care facility. And the home is infested with animal feces. It's got holes in the floors. It's unsafe at this point. I sent photos over to Mr. Wisniewski last week of the condition of the exterior and
Mr. Wisniewski, wait, Mr. Wisniewski is the guardian?
Yeah, he's the attorney for Guardian Care Inc. Yes.
Oh, he's the attorney for Guardian Care Inc.
Mm-hmm. So Mr. Jones is currently in a long-term physical rehabilitation center, and he will not be returning to the premises. He cannot live by himself anymore. So the home remains titled in his name solely. And like I said,
Appreciated it. Why didn't Mr. Wisniewski just remain here? Couldn't he do that for us?
He had a circuit court matter he had to go in person for, I believe. But like I said, I've been in communication with him for the past few weeks on this matter, and he doesn't oppose the motion.
All right. All right, there being no opposition, nobody's here. I'll enter the order of eviction, allowing removal of the home from the premises and awarding ownership of it to the plaintiff. You can prepare an order.
Thank you very much.
Send that over.
I will, and I'll send a copy of the order over to Mr. Wisniewski once it's been signed, and I'll give him a heads up before the home gets removed, just in case he wants to remove anything else.
Thank you very much. Have a good day.
Thank you, Judge. Have a nice day.
Take care. You too. Bye now.
We were trying in custody and then we had the sons.
Trenton in custody?
Yeah. We're out there.
All right. Sorry, guys. Evelyn Valerie Cook, 22T705-215.
Morning, Your Honor. Peter Bernardo, 278-413, NYDC counsel from Cook.
Your Honor, the defendant's not on camera.
Are they there, John?
I called them.
Let's do Malone. You have Malone too.
Yes,
Matthew Malone. Matthew Glenn Malone, 25B148976. 25B149968. And I am going to need in here Jessica. Give me 1 second, if you would. I also have 26B150688B. So I have the case that I took under 7411.
I'm trying to listen to both. I've got two cases going on. One on my right ear, one on the left.
Mr. Malone, your name?
Mr. Glenn Malone.
Did I ever order a pre-sentence report on the controlled substance case or a screening and assessment?
There has been. I went over it with Mr. Malone earlier today. I believe there's a probation report in there.
Where is that at? Ms. O'Donnell, your name?
Just
I'm a little confused on these. I tried to give him an early hearing date. He was in front of me on Friday, I believe. I set a bond of $1,510 on Judge Hessens. That's a trespass charge. And then I set one of possession of a controlled substance. Which is 26B150688B. That's a May 10th incident. And then I've got another trespassing case, June 26 of 25. I put him on probation on September 24, 25. He pled guilty on May 11 of 26 to failure to refrain from re-entering the Televalley Mobile Home Park. Did I order any kind of pre-sentence report on these?
Even a pre-sentence report. I don't have anything like.
Not even when I did the controlled substance charge?
So the only thing I have him on probation for is the 25C148976. That's the only file I have in probation.
Right. Judge Heston has this other one. Let me check something here. Surprised I didn't order a pre-sentence screening and assessment. Mr. Malone, are you going to show up or what?
So
I said, are you going to show up or what?
absolutely, I showed up today for you. They showed up. You all were mad at me last time.
Oh, because I don't go for this nonsense.
Yes, sir. I apologize.
Listen, here's what I'm going to do. I still want to have a screening and assessment on the 7411 case. I wanted to give him the benefit of the doubt and have this early. I mean, it was just in front of me on Friday. I didn't want to keep him in custody. I didn't think he could post a bond. So I'm going to order a screening and assessment. We're going to reschedule this.
Judge, this case was taken under the 771. This probation date.
The trespass case. I know. But I took the other case under 7411 on 688B. That's possession of a controlled substance. I never ordered a screening and assessment.
Right.
And that's what I'm going to do now since he's out of custody. I was just trying to rush it through for him because I didn't want him to sit in jail for a long time.
I appreciate it.
So let's give us another date on this one. And I don't know when that would be. Heather, are you out there? Yeah.
I am, Judge. Do you want to do next Monday? Because your dockets after that are pretty filled up right now.
Yeah, I'll do it next Monday.
I'll be here
We
next
could
Monday.
do it
8:30?
9:30?
Yeah, that's fine.
Okay.
My dockets are filled, huh?
Yeah, you're pretty full. It's gonna be a busy month.
Okay. We're all laughing at it. All right. And then I'm going to adjourn the sentencing on these to June the 8th at 9:30. You're going to go down the hall. They're going to give you a notice. Your bond's continued. And we'll order a screening and assessment, and then you're going to go over to probation where you'll fill out a question and be interviewed. Okay?
That's right.
And any questions? Show back up.
The guy that posted my future boss that posted the bond, he gets his money back, right?
Not now.
Now,
Not yet.
Not yet.
until the next Monday then?
Okay. Listen, you're going to come up with some money, though.
Yes, sir.
You, right?
Yes, sir.
Where do you work at again?
I don't work on homeless. The guy that bonded me out is going to be my future boss.
Well, good. Start working for him today. Can you start working for him today?
No,
Why?
I gotta get my license back. Nothing, I gotta get my license renewed. So you go to court, I'm gonna bond you out, you go to court, do the right thing. And I get my money back, so I'm gonna help you get your license back and then help you get a job. Just trying to get me back on my feet, one step at a time.
Well, that's good.
Yeah.
All right. Well, I can work with you. Go ahead. Take care of that. You'll be all set, okay?
I appreciate it.
All right. Good luck.
See you.
Evelyn Valerie Cook, 22T 705 215.
Morning, Your Honor. Peter Bernata, P78413, MIDC counsel for Ms. Cook.
Ms. Cook, your name, ma'am?
Evelyn Valerie Cook.
Your Honor, we will wait for Maureen to stand. We ask for their document input.
How many times you gonna miss?
I've been in Wayne County Jail and they just picked me up at my house. I got out on Friday and they just picked me up Friday and brought me here. I've been here since.
How long were you in the Wayne County Jail?
15, 16 days.
Well, you were not here when you were supposed to be here on November 4 at 25, December 23.
Yes.
Hang on, ma'am. Don't interrupt me.
Sorry.
You were not here on November 4 at 25. You were not here on December 23 at 25. You were released on a PR bond on March the 9th. You were supposed to be here March the 23rd. You didn't show up for that either. You got a big problem. You got to show up in court, young lady.
Yes, sir, you're right, I do.
10,000, 10%. Do it again, I'll make it 100,000 cash next time. You've ignored us long enough. We'll give you a new court date. We'll give you an early court date. I'm telling you, you're playing with fire by ignoring courts like this, okay? You do what you got to do, all right? I'm just telling you, you're not going to play this game with us again. Do you understand what I'm telling you? Next time I'll make it 100,000 cash, and I'll set the court date way down the road. Do we understand one another?
Yep. I do. Yes, I do, Judge.
Gonna be able to post this $1,000?
Probably not.
Well, Nick, that's too bad. We're gonna give you a court date on June the 11th. Is that what I'm doing, Heather?
Yeah, Judge Kirsten will be here that day. Judge Kirsten will be here that day.
I'm sorry?
Judge Kirsten's here on June 11th. That's the next day we have Trenton, though.
June 11th at 10:15. Okay, same bond conditions. Good luck. LBNV versus Thomas Roth. 22T 2941. Sorry, Mr. Granada, they can't do that. All right, do I have the parties here on this one? This is 2941. Good morning, Ms. Serby, your appearance.
Yes, good morning, Judge. Francesca Serby for plaintiff P87205.
Your Honor, this is a motion for entry of judgment against Garnashee.
Oh. And the Garnashee is 2J Group Inc., right?
Correct.
Yes, Judge.
How were they served? Not appropriately, probably, right?
They were served via certified, and then, yeah, they were served for cert, and then a green card was signed back in November of 2025.
No, I'm talking about the Garnashee.
Yes, Your Honor. They were mailed a copy of the writ of garnishment in November of 2025 and failed to disclose.
Mailed it, but that isn't good enough service, is it?
Let me triple check this. I believe it was just mailed, Your Honor.
So you guys, they can't submit a default judgment request, a proposed default judgment on a Garnashee defendant when they're not served appropriately. You follow me? I mean, I do not understand why lawyers do not follow court rules. I'm not getting on you. Everyone does it on these Garnashees. But then they want me to enter a default judgment, and I can't enter a default judgment because there isn't proper service. And then I have to set every one of these for hearing because nobody serves them appropriately. And I literally mean nobody. I'm telling you, nobody. And I don't know if they're just disregarding the court rule. They don't know the court rule, the combination thereof, or whether it's too expensive, they feel they have to hire process servers to serve Garnashee defendants. But I cannot, in good conscience, enter a judgment against the Garnashee defendants. So motion for entry of default judgment versus Garnashee defendant denied. Sorry, Ms. Serby.
Okay, we just had motion in court. We just zoomed out. No audio yet, but we just zoomed out away from the wall. Thought I'd bring it to you right now, waiting for confirmation.
Thanks, sir. I'm Madam Floor Lady. I received your note, and I appreciate the information. And basically, it seemed like an update of sorts. So what I'm going to ask you all to do is and I've shared as much as I could with the lawyers. what you folks do back there is none of any of our business, so I didn't share it all. But
they're hung.
I'm gonna ask you to continue working. If there's anything we can do to make you more comfortable, snacks, drinks, just let the bailiffs know. And I'm gonna ask you to continue your deliberations, and we'll be here if you need us. All right?
They're hung. That's my call. We had the audio on the whole time. We have not missed anything. Clearly, the jury foreperson shared information about deliberations with the judge, which she's not allowed to share with the lawyers, and she's not supposed to share with the judge.
Any exceptions from the state?
No, sir.
Sam? No. All right. We'll be at ease again until further notice.
I think this is going to be, yeah, that was close to a dynamite charge. Just go back, keep working. If there's anything else we can give you, drinks, snacks, dinner, breakfast, lunch. Yeah, I think they're stuck. I think the cameraman also was late coming back in and missed part of that. So let's see. Let's jump back to there was nothing. There's no question there basically. So if you're wondering what was the question, what they ask, we don't know. We missed that. Everybody missed that. All we heard is that there's a note that was given to the judge. Some of that information that he was shared with the lawyers. The response that was given to the jury was that they should go back and keep working. And if they need anything like snacks or treats or something like that, then let us know, and we'll wait for the next note. So that sounds like a hung jury. If it's hung, will the state retry? It depends. First of all, I don't think this is an extremely expensive case to try. Looking at it took a day and a half for the state to set their case out. That's not a ton of time. It's not like a 12-week trial, something like Murdaugh all over again. Murdaugh's expensive. They're going to probably retry that one. So I think they will retry this, but it also depends on what the jury, what the tally was. At the end of the day, if the votes come back from the jury and there's 1 guilty and 11 not guilty, well, that probably weighs into the equation a little bit. Do we retry? Do we try to find a completely different panel that would see it differently, except for one person? So I think the state would refile based on the public outcry over this case. And there's a lot. You guys want to see that part again? Give me a second here. Okay, here we go. Let's go back. This is the whole thing that just happened. If you just missed it, the comment and everything, and this is from the moment this is mics up, camera shake. I brought you guys in about right here. Judge hands a note back over to the bailiff. Wait for the audio to come up. This is just a note, guys. This is just a note.
Jury's seated, Your Honor.
Jury's seated.
I'm Madam Floor Lady. I received your note, and I appreciate the information. And basically, it seemed like an update of sorts. So what I'm going to ask you all to do is and I've shared as much as I could with the lawyers. What you folks do back there is none of any of our business, so I didn't share it all. But I'm going to ask you to continue working. If there's anything we can do to make you more comfortable, snacks, drinks, just let the bailiffs know. And I'm going to ask you to continue your deliberations, and we'll be here if you need us. All right.
That's it. What that is, that's a note from the jury saying we're hung, we're deadlocked. And the judge says, you're not done. Keep working. He can't order them to reach a verdict. That doesn't work. But he can do what he did. So we're going to jump back ahead here, real time. None of the lawyers objected to anything there. So back in real time, back on the watch, we are at, let's see, verse 6. We are at 4 hours of deliberation now. 4 hours of deliberation for the jury. They need the jury instructions. They want the jury instructions. The judge won't give them to them. He thinks they're his. Well, let me give you a hint, Judge. It says jury instructions, the jury charge, not judge charge. Give them to the jury. He's actually worried that if he gives them the copy, then the people will cling to one, excerpt from the jury instructions, the jury charge, instead of taking in the whole document. I'm not sure how that rationale works, but that's his thought process. This happened in a trial a few weeks ago. They came back with a guilty verdict eventually. Yes. 1 hour per day is what I go by. Let's see, Crystal, we're on day 4. And we're basically 4 hours in. The first hour was lunchtime, but they were ordered not to deliberate during lunchtime. So technically, I think we could say 3 hours on this counter and be right. Big problem is lack of objections during closing by defense. Some judges will say, hey, closing arguments are not evidence, and just let it happen as long as it's not egregious. But there were a couple things, some facts not in evidence. I think they made one objection during closing that was overruled, and that might have been like had a chilling effect on defense using any other objections. If they come back hung again, it's the dynamite charge and more deliberations. We're not getting a verdict today, in my opinion. Let's see, South Carolina, what do they call their dynamite charge? Let's see. South Carolina. See, in South Carolina, a dynamite charge, also known as an Allen charge, is an instruction given by the judge to a deadlocked jury to encourage further deliberation and prevent a mistrial. However, because it risks unconstitutionally coercing a verdict, South Carolina courts view it with strict scrutiny. When a jury reports it's unable to reach a unanimous verdict, the judge may read this special instruction. The charge reminds jurors of their duty to listen to each other's arguments, re-examine their own views and opinions, attempt to reach a verdict if they can do so without violating their individual conscience and judgment. And the limits on this in South Carolina, the appellate courts require trial judges to handle the charge with extreme care. A dynamite charge will be overturned on appeal if it's deemed unconstitutionally coercive. Judges cannot specifically target or single out a minority or hold out jurors, imply an explicit or implicit deadline for reaching a verdict, pressure the jury by emphasizing the financial cost, waste, or burden of a mistrial, and fail to remind jurors that they should not abandon their honestly held beliefs just to reach an agreement. So we can expect that is still an option on the table if we get there. By what law could they find him not guilty? It would be self-defense, defense of others. They chased him, then shot him in the back. He was running from them. How are they threatened by a boy who was running from them? JJS, if the jury finds it was self-defense and defense of others, it would mean that they believed Andy, which is evidence, was testimony that was offered during court from the witness stand under oath. If they believed that, then they would say that Cyrus pointed a gun at Andy, which was a threat. They were legally allowed to chase him. That's a fact. They are legally allowed to chase him. There are actually protections for shopkeepers for chasing people they think may have shoplifted, not know, but think may have shoplifted. So that's okay. As far as the shot in the back goes, the shot in the back is because, according to Andy, he was pointing the gun at Andy. Cyrus was pointing at Andy, and Dad was in back, and that's why he shot, and it hit him in the back, and that's why you've got this left to right and upward and everything trajectory. And the threatening is at gunpoint. That's lethal force. So they can reach it. That would be the logical conclusion the jury would have to reach to do that. They might come to the complete opposite conclusion that the Chows were instigators, did not have a right to self-defense because they began this, pursued him off the property, 130 yards, and they might also find that they didn't believe Andy and didn't believe he ever pulled the gun. If that's the case, then the guilty. I think the jurors would have to sort of somehow rationalize in their mind the whole idea of the state saying the gun came out when he fell and that the gun was with him up further, and how it got there, and then how none of the witnesses that the state presented could account for the gun at all. They'd have to rationalize that away in some way, but a juror could come to either conclusion. Let's see. Still nothing going on in court. Let's see, why is that making noise? Is that my headphones? Okay. His prior acts make me think he could be irrational about people stealing from him. Coffee time for D. You have to also consider that those prior acts were also investigated by the police and deemed constitutional. That he was in the right. So that same argument could be argued the other way, saying he's experienced in this area, knows what he can do and can't do, as we have example from prior acts where he acted within the law. It was not a formal Allen charge. That one does not count. Did they come back deadlocked? We think there was a note that came back that indicated the jury was having a hard time reaching a verdict. Gail Pett says, I highly doubt that he pointed the blammy. I'd say Andy saw it when Cyrus fell and yelled as much to his dad. His dad was trigger happy. That's all in the purview of the jury to decide. Gail Pett, you're 100%. If you were a juror, you would be 100% right to come to that conclusion if that's how you felt about the witnesses and their testimony. If Cyrus was just holding the G and not aiming it, would it still be self-defense? No. You can't shoot someone for brandishing. There would have to be something else. It would have to be pointed, or for there to be a threat. Even police are very careful not to just shoot someone when they see a weapon. There has to be a threat, and they're very good at recognizing that motion that could turn into a threat. But the threat has to be there. Let's see. That is a great question. It is. So confused about this one. If they were constitutional, then he thought he was in his rights to chase. This is horrible. Coffee time for D. I agree. I've actually told you my thoughts on this one. I disagree with what the Chows did. I can't say that enough. I disagree. I do not think they should have done that. I'm very disappointed with the choice they had to make, but with the choice they chose to make. But I believe under the South Carolina law, they were within their rights, and so that they felt they were acting in self-defense based on what they knew, which was mistaken belief, which led them to that situation. But also, Cyrus had the right to self-defense in that moment. Like, in the facts as it happened, I believe Cyrus, even though he was carrying an illegal, or a gun illegally as a 14-year-old, I believe he had the right to self-defense, and him pulling the gun and even aiming it at them would have been justified. Now, there is the only issue, the only asterisk I put there with Cyrus' right to self-defense is that he did, in his mind, know he just broke the law. Or he did just break the law, and he was the only one who knew it. He had carried a firearm into a prohibited area, which was the Chow's store. I believe that's a felony. I'm not sure on that one. I have to double check in South Carolina if it's a misdemeanor or a felony, but it is against the law. So he's the only one who knew he had just broken the law, but he hadn't done anything aggression-wise to the Chows. So in his mind, there would be no idea that he had instigated anything. So he definitely would have the right to self-defense when two grown men are chasing him down, yelling at him. So now you have two parties defending themselves against each other, and both of them are legally right. Now, how does the jury decide? One of them is dead, and that's just wrong. But in this case, I think the decision is to go with a not guilty in the criminal court and a guilty as all get out in the civil court. And it doesn't bring Cyrus back, but neither will putting Mr. Chow in prison. I think it's a civil issue if they were both following the law. All right, we're staring at the flag, just seeing if I was hoping that the jury would come back with a quick note after they got that instruction. I mean, they've already had 2 notes in about a 3-hour period, roughly. So bringing a 4th note might be good. Let's see. Selena K says he's guilty here, and I'm so bothered by the facts. He shot him in the back while running away. Seriously, you can't discount Andy. I mean, you can as a juror, but I can't as a, just objectively looking at this under the law and saying what outcomes are legal to reach. The Andy saying he was threatened. Here's the thought process that gets me there, and I'll explain it. Under South Carolina, under the shopkeeper's doctrine, not only are the Chows protected from stopping shoplifters, there is a law that protects them from stopping people they think that shoplifted that didn't. They're protected if they grab them and restrain them and say, nope, you're not going anywhere. You're staying right here. If they chase them down and keep them from leaving, they're protected from being charged with kidnapping, from unlawful restraint, from assault. These are things in the South Carolina law that protect shopkeepers when they're trying to stop someone from shoplifting. How do you stop someone from shoplifting? I can tell you it can't happen in the store, because the act of shoplifting involves them leaving the store with items they haven't paid for. It has to allow for something to happen outside the store, and that law does. If for some reason they had caught him in the parking lot and dragged him back in, or just held him right there until police arrived, which I think they would have called, they would be protected. He could not sue for anything. Even if he proved that he hadn't stolen a thing, they could not sue him. They were in the right there. So if they were in the right to leave the store and pursue him and try to restrain him, even keep him from leaving, and they would be protected under the law, you can't use that same act and say, but that's where you went wrong. And might not like it, but that's the law in South Carolina. Do you believe, Andy? That's what it all comes down to. I agree. I think the state tried to twist Andy's words a little bit, even doing the same thing the defense accused them of in their closing statement, where they used part of Andy's statement, where they said not to say, and they stopped right there. But Andy continued, they said not to say what someone else saw. And they were asking him questions about what his dad saw, or what his dad learned, and what things that Andy did not see. So when they use that against him and say he was being evasive and shifty eyes and looking at the lawyers are the ones who told him, you can't say anything someone else saw. For the state to use that against him was dirty. I think that was wrong. I don't know if he's telling the truth. I know he was extremely consistent, and I've never seen a witness so consistent with and so vigilant at not sharing hearsay. Let's see. Either way, it's going to be a tough verdict, no matter what the jurors decide. I agree. If that's the law, then how do they charge him? Well, the prosecutor chooses whether or not to charge. And if they think the law is different, then they charge him. And if the jury decides that it's different, then they convict him. And if an appeal upholds that conviction, then the law's changed. That's sort of how it goes. I respectfully disagree. He studied a script and stuck to it. Jody, I don't think you can say that, because he did the same. He said the exact same thing to the police without being able to talk to anyone else. We've got someone on the phone. Hang on just one second. He was the first person the police talked to.
This is Bap.
Bap, how are you doing? Long time no talk.
I'm good. Yeah, it's been a really long time, right?
Yes. Thanks for calling. What? Share your thoughts on this. Enlighten
Yeah,
me.
overall, the whole thing is sad, first off.
It is.
I think probably the thing that's sticking with me the most, and it might be because in some ways I can relate to this whole thing a lot, but I think the thing that's sticking with me the most is just, it's an example to me of how much the victim is on trial just as much as the person who is accused of the crime.
Say that one more time. It's a
a reminder to me of how much the victim is on trial just as much as the person who is accused of committing a crime.
Which is not fair in this situation, because we have nobody to speak for him and nobody who can tell us what he was thinking.
Exactly.
And so,
do you remember last year, I think the young man's name was Colin, who was accused of unaliving his mother.
Is that the Florida
after
one?
Yeah, that was in Florida. Okay. And it seemed as though people's perception of the mother ultimately led to him being found not guilty.
Yeah, that was a rough one. I didn't agree with that verdict. I had a really hard time with that jury.
Yeah. Now, there are some legal reasons why Mr. Chow could be found not guilty, but I do think ultimately a lot of it is going to lead back to people's perception of Cyrus.
Yeah. Huh. That sucks. That sucks, because the victim should be the one that the law is standing up for, right? And
right.
And he's the voice that should be heard.
But we live in reality, right?
Sadly, the parts we're getting from his story is his Instagram story with him flashing a gun at 14, and the fact that the police say, yeah, he had a loaded 9mm on him at the time,
right?
And that becomes the narrative.
Sometimes your worst decision can end up being, the last decision you make.
Yeah.
Unfortunately.
Yeah. So as a juror, you've got to vote here on this one, Bap.
I could not be a juror on this case. I would be way too biased. I have nephews, Cyrus's age.
Yeah.
And I literally see them in Cyrus, so I could not be a juror on this without being biased.
Yeah. I hear you. Bap, I appreciate
I literally have I have a 14-year-old nephew who kind of looks similar to this young man, and it was kind of eerie. Yeah, I couldn't be a juror.
Yeah, I hear you. Thank you very much. Appreciate it. A lot of people in chat saying they agree. They agree with you. So thank you. Thank you for sharing the thoughts on this one.
All right, and always good to speak with you.
And don't wait so long to call next time.
All right.
It's been forever, months. So thank you very much, Bap. All right. Are there any people in the courtroom from Cyrus? I'm sure there are. The camera has not been showing the gallery very much. Let's see. I believe Andy saw Pew Pew in the kid's hoodie. I don't think for a second that the Pew Pew came out. Baby Shark, the problem with that is the state says it came out. Both sides say it came out. The state says it fell out when he tripped and that he was picking it up to continue to run with it, not pointing it. That's the state's argument in their closing. But they say it wasn't pointed. But none of the state's witnesses agree with that. None of them saw the gun. But the state says he had it. His DNA was on it. His fingerprints were on it. It was loaded. The sight, the flashlight, the laser light was way off down by the curb where he fell the first time he went down. That's where the light was. And the state says that's where the gun fell out. So let's see. I remember the state saying the tack light fell out. If you go back and listen, they say that's where the gun came out, hit the ground so hard that the light broke off. Is Andy going to be charged? I doubt it. I doubt it. He was in front of. I mean, there's evidence to show he was in front of his dad for most of the time. There's no evidence to show they were communicating with anything before or after, before or up to that moment. And there's no evidence to say he even put his hands on him, and he wasn't carrying a weapon. So, I don't think you can get him as accomplice, because you'd have to prove that there was some sort of, that he was in for an illegal act, and I don't think you can prove that based on the facts that are out. Is it just me, or is everyone just dismissing the possibility that Mr. Chow could have had some racial bias prejudice that fueled his decisions in the case? It's possible. We've been trying really hard to not look at this case or any case with a lens of racial. How do I say that? We try to keep that argument out. We try to look at just the facts as if we didn't know who anyone was. We didn't know their background and didn't know the situation and it's difficult to do, because sometimes you look at it and says, well, that matters. That's important here. But I don't know a better way of doing that. It's a very difficult discussion to have online, and it's going to trigger a lot of very strong feelings. I don't think it can be a productive discussion in this venue, in this format. Let's see. Why would we ignore racial bias when they could be what made actors act? Probably because you'd have to prove it, and you've got probably a large percentage of this store owner's customers would fit into the same class as Cyrus, if you're trying to group them together, and so you're going to have hundreds of interactions on video and otherwise of examples of them not acting a certain way with somebody, and then this example of someone with them acting this way, and you're probably going to have plenty of other kids of various racial backgrounds that are trying to steal something out of the store on the wall of shame. So I think they could probably disprove that really quickly. Colin, I think Colin was surprised when the jury found him not guilty. Just about fell out of his chair. See, Bat answered a question really quickly. Someone asked if I'd be okay if my nephews had a weapon. I think having a weapon was the worst decision Cyrus made. I agree. But man, 14 years old, your brain is not formed. You're not thinking through, what are the long-term repercussions of this decision? Is this going to affect my ability to go to college? Is this going to, three weeks from now, could this end up in somebody getting hurt? Your brain doesn't go there. It's much more, impulse driven, and terrible decision to have a gun, but ignoring it makes it an issue. RA, I'm trying not to ignore it, Sub Rosa, but I'm trying also not to make it the issue when it hasn't been brought up that way. Like, if you look through all this case from both sides, this was not presented with a racial focus on the case. If anything, you could say that the Chows themselves were more of a minority in the situation because of their ethnicity. I feel racial issues are important to talk about. It could be the cause in some cases. It's easy to see. It's hard coffee time for me. I mean, I'm speaking personally. It's hard for me. I'm not saying you're wrong. I'm just saying I don't know how to do it well, effectively. Let's say Mr. Chow gets off. Does he successfully continue his business? I don't think he has it anymore. I'm not sure if it closed down or he shut it down, but I think they're not there anymore. I think it's done. Laura, I'm with you. I hear you. I think what for this to work, for a conversation to discuss heavy issues like this and difficult issues like this to work, we have to be in a situation where we can all listen to each other and listen with I'm going to try to understand it from your point, type of vantage point where you can explain to me and I can say, this is completely foreign, but let me see it the way you do. Explain it to me in a way that I can understand something that's not familiar to me, that you feel as strongly about one way as I feel the other way, if that's the case. I think that discussion for me personally has been much more effective one-on-one than in a large format where there's popcorn type answers and responses that jump up, and that's why I'm saying it's difficult in this environment. I think that the best way to have this type of conversation is before you sit down for a debate or even a panel discussion or something like that. Just spend a day in the other person's shoes. Just walk their walk for a while. Understand where they're coming from before you decide to fight and duke it out. Become friends first. Find where your similarities are, because I'm telling you, most of us have more things in common than we have, that separate us. Let's see. One thing that gives me comfort is the jury seem to be taking it seriously rather than just throwing in the towel to what is more popular, so they can go home. I do have confidence in juries, like across the board. I know a lot of people are like, I don't know if I really trust the jury. I do, even though I don't know any of them. I've never sat on a jury myself. I don't know why, because I would, in a heartbeat, I'd love to serve on a jury, just to understand that perspective of it. But I inherently say I'm going to, first of all, believe that a jury is telling the truth, is doing the right thing, is following the instructions, and that they find this opportunity to serve, just right below the high duty of serving your country, or the opportunity of serving your country. Serving as a juror is right below that. Is there a cutoff time for today? We haven't heard one. If there was, let's see. How can you spend a day in someone else's shoes? As hard as I try, I often fail. Well, that's because the shoes don't fit, right? I think the best way to do this is to not try to sit down and say, okay, I'm gonna go and live in your neighborhood or something. Just hang out with each other. Play a game of checkers. Cross a barrier that you're not comfortable with. Go to a restaurant and share a meal. Buy the other person a meal, first of all. If there's somebody you don't agree with, take them out to lunch and let them choose where you go, and pay for it. And then, just talk to them. Be like, look, I don't understand. Admit the weakness. I don't understand. Help me understand. It might not change my mind at the end of the day, but we don't have to come at it like we're enemies. Hang on just 1 second here. Sorry, we've got like 6 things being recorded at once. All right. Well, it's easier for me to say it than it is to do it. And I'll be the first to admit that I fall short of my own expectations. All it takes is, me on the road driving somewhere and somebody cuts me off to to see just how well I stick to my mantra of smile at someone to make their day better. It's hard to do it sometimes. It's really hard, and it's easy to jump to the other side. Super T says, I don't understand. Now who wants to buy me lunch? Is there a verdict yet? There is not. We're watching live. This is the live view of the flag in the courtroom, and we're just waiting for. I was hoping the jury to decide to send another note, because the first one sounds like they were in fact deadlocked. It's now 5:00. Jury's deliberated for 4.5 hours, 3.5 if they didn't do anything during lunch. Laura says, I feel strongly about a lot of things, but the internet isn't always a good vehicle for that activism. It's your heart and the company you keep and your open-mindedness to hear people out. Laura, I appreciate it. I appreciate you sharing things in chat as well. I know sometimes it's hard to put down what we feel and, in the few little words we have in a chat message to try to convey a whole thought or a viewpoint. It's difficult, but I do appreciate it. Ask questions and actually listen. Don't think about your response while they're talking. Really listen and ask follow-up questions. Listening skills are underrated. The best thing I could tell somebody if you're going for a job interview or interviewing, somebody famous, listen. Listen to what they're saying and respond to what they said, not to what you want to say next. That is good advice. I think he sold his business to pay for his defense. Or maybe he just sold his security system. That's a ton of money. There's a ton of money there. Oh, Joy, thank you so much. I apologize. By the way, I love your robot. One day I'll get a robot. Do you have time now to answer my question? Yes. Let me go back and grab that. Just one quick second, Joy. Let's see. Can you explain, she says, can you explain again how the defense was allowed to bring in the body cam statements of their own client, if not hearsay or for completeness? So normally the defense is not allowed to bring in a recorded statement by the defendant. The prosecution can, because that's a statement against interest by the party opponent. That's fair game, so they can play all they want. But the defense normally can't. In this one, when the prosecution was playing the first officer's body cam, and they played it up until when he turned and walked away, the defense objected and said under rule of completeness, and they cited the law, it was something 106, that said that even another statement can be played if needed. And they had some really strong support for that. The judge didn't change his ruling, but said, look, I'm going to let you, and this was with the state's, this is most important, I think it's with the state's stipulation that if they could lay the foundation, they would let it in under their case. And so they did that with the second officer, but they had to wait until the state had rested before the defense could take over and then play that other audio. So it was hearsay, but it was sort of allowed by the state and the judge, which was sort of weird, because the way he did it, I think he should have done it in the moment if it was the rule of completeness. And if it wasn't rule of completeness, it's definitely hearsay. So it's a valid question. And if the state could appeal a not guilty, if that's the way it goes, I think that's one of the grounds they would appeal on, because I think it was the wrong decision by the judge. Excellent question, though. Let's see. If it's in discovery, it's fair game. Yes and no. There are still the rules of evidence that have to be met. So you can turn over a whole bunch of stuff in discovery, but if you can't authenticate it, say you have video, like somebody just emailed you video from somewhere, anonymous at gmail.com just sent us all these videos of the crime that we didn't know existed. That would not be admissible in court, even if it might actually capture the crime, because you wouldn't be able to authenticate where it came from. Nowadays, someone could argue that's AI generated. This was somebody just made the computer create something. They put the faces on there and made it look like it was real. You have to be able to authenticate the source, and that's why we often get like the custodian of records called in, or the manager at the gas station who's like, "Yep, it's my job to change the tapes on the RC on the recorder," And starts that chain of custody and the authentication, which is necessary to allow the evidence to be admitted once it's authenticated. So just because it was in discovery doesn't necessarily mean it can or should be brought into court. When you are refreshing someone's recollection, on the other hand, anything is fair game, but you just can't show the jury at the same time. You can give somebody a ham sandwich to refresh their recollection. It's 5 p.m. in South Carolina. I think they will call it a night soon. I think it would probably within an hour. Just looking to see. I thought we saw motion there. No motion yet. How long will they deliberate? The judge has not given us the time on that one. So if a crime is caught on a Ring camera, it's hard to bring in? No. Especially if it was stored on the Ring on the cloud. You can subpoena the footage from Ring itself and bring it in that way. And Ring can say, this is authentic, it was recorded on this date, here's the file, here's all the metadata behind it, the camera, this is how it captures it, this is the timestamp, and I'm verifying that this is real. So it can be brought in. We've seen a lot of Ring camera. Hey, Mrs. R.A., my wife's here, welcome. Red Pen says, Mrs. R.A., my vote is let's go. It's our anniversary, I have to go soon. Red, you got to get out of here. We need a poll. Should R.A. eat on screen or wait until after the verdict? Basically, she's saying dinner is ready. Red, thank you very much. Thank you very much, Red. Go enjoy your anniversary and tell your significant other to that we're sorry. Going out to eat soon. Have fun. Have fun. Have a blast. Happy anniversary. 41, right? Was it 41 years? Is that what we saw this morning? I think that's what we saw. Wish it was in that jury room. Me as well. Let's do a virtual potluck. I'll bring some snacks and a drink. We need that sound effect from Judge. Hey, get out of here. Get out of here. Don't come back. To Red. Red, get out of here. It's your anniversary. If you're a juror and can request snacks, what are you asking for? Well, I would probably push the envelope a little bit. I would ask, that's so awesome, 41 years, congratulations. I would probably ask for something a little bit unique. Like if there were going to be like chips there, I'd want like salt and vinegar chips or maybe some Old Bay chips or something like that, a unique flavor. A candy like probably Swedish Fish is usually a safe bet. I think they're even kosher. I don't know. Somebody tell me but they're vegan, they're kosher, they're delicious, they're fun to eat. I'd request Sour Patch Kids. A little bit of hey.
I can talk if you want to go off screen.
Food came to me. It looks like this is a is it linguine?
No, it's fettuccine.
What do you call it?
It's just fettuccine.
Just fettuccine Alfredo, but it's got some.
Okay, guys, this was supposed to be an amazing dinner with like sliced zucchini that goes in there and poached baby tomatoes. It was going to be amazing. But I blithely ordered all of my groceries from Walmart and then got home, did never check to see if they actually gave me what I ordered. They didn't. And also, I'm an idiot and bought cucumbers instead of zucchini. So I got into it, cut the cucumber, and I was like, this does not smell like zucchini. I was like, oh dear. So it's fine, but yeah, it's not what it was supposed to be. The recipe was not followed precisely.
It still is tasty.
It's a unique palate because it's got lemon in there and basil.
I taste the basil. The basil's a strong flavor in there.
Yeah, it's interesting. Anyway, I'll run the mic if you want to eat, or I can just take off and you can eat and talk to them.
Well, do you know what happened in this story? You have to cover it really quickly.
Oh, no. I would talk about stuff that has nothing to do with this case. I have no idea what's going on in this case. But guys, I can talk to you about painting things.
I painted the entryway.
Yes.
This week. Well, in the last week. It was last week.
Yes.
Do you want to sit down here and run the mic?
Well, I'm wearing pajama pants, so can I just use this mic over here?
Well, you can just be like, see what you got there. This would be all you see right there.
Oh, okay, yeah. Let's do that.
Okay. All right. So you have to sort of squat down. So you see, look.
There's skill involved. Okay. Okay, lie to me. Tell me you did not see in my pajama pants. Oh, sorry. Okay, so here's the thing with the entryway. I should look at the camera. I have a friend who's just amazing, and oh, sorry, I am so much shorter than Scott. You just hang out and look at my forehead. My friend came through and she looked at this house and I was like, listen, what do I need to do to make it look amazing? And she walked through and she's like, it's not bad. You know, you can do this, you can do that, and move this over here and change this angle of that and maybe put a picture on a wall. I don't decorate. And she walked into our entryway. She goes, oh, you're going to need to paint that. I was like, oh, that was not on my short list, but I guess we're going to need to paint that. So paint it, Scott did. And it looks fabulous. It used to be an outside part of the house, and then they, I did not see you in pajama pants. Good job. Who's that? Play on crime. Good job. You are my friend. Good job. Anyway, when he did paint it, it was all just white. It's shiplap, and it's all white. And I thought, I mean, it's white. If you wash it, it'll be fine. But no, this house was built a long time ago. I'm pretty sure it was the original paint. And so when he put the paint on it, I was like, oh, that's what white looks like. It looks much, much better. It's really pretty. Yeah, right? Not. Tell us about the new car. I love the new car. No, we have not named the new car yet. Dinner break brought to us by Mrs. R.A. What color? The car is gray. Dinner is sort of whitish. Noodle color. It's noodly. It does have a lot of dents. It has a couple of dents. It has some personality in it, but man, that thing can move. I feel like Poe Dameron when he gets in the bad guy's spaceship. He's like, whoa, that can move. That's what it feels like. You get in that car, and I'm used to having 8 cylinders, but also a huge vehicle that it's trying to pull around. So this has 6 cylinders and just a little tiny car. I mean, it's not tiny, but it's much smaller than a Yukon, and so you can punch it. You can get up to speed really fast, and it's pretty amazing. What color is the entryway? It is white with, my fault, some really awful green on the trim. I just looked at the picture, the little color, the piece of paper that has a color on it, and the swatch. And I was like, this looks good. And it does. It looks really good on a tiny piece of paper. You take it and you put it all the way around doors, and it's like, that's not a good idea. So we have quite a lot of paint left, that green color. I'm trying to get a little bit taller so that you can actually see me. And I don't think we're going to use it because we have to sell the house, and I don't want people to look at it and say, what happened there? So how was your adventure with the early morning flight with your son? Guys, it never ceases to amaze me how many details of our life that you know. It was good. It was fine. We went and I took my 2 oldest who are at home right now, and one was flying out and the other was supposed to keep me awake. And it was fine. I had to wake up at 2 a.m., but it was only for an hour to take him to the airport, and then I got back to the hotel and fell back asleep again. So it was good. Green is always good, even if awful. It was bad. It's not good. And the thing is, we were supposed to paint the trim in that room, the back porch, and the front steps, all that same color. But I'm like, no, we gotta do something else. The question of the year, who knows? I don't know. Does the paint match my shirt? I think if it did, it would be awesome. Can you see through my shirt? Or do I look like I am the courthouse? I don't know. Actually, you know what it matches? It matches the green screen. If you could take away this courthouse and just see the green screen, that's the color. There's a lot of time RA has to fill. We do know quite a lot. I picked a mauve once for my living room. It was terrible. It looked like Pepto-Bismol. Oh my gosh. I got to tell you, when we first moved here, I had not seen the house at all. I mean, I'd seen it on video. Scott had walked through and videoed it when he was here. And I was like, okay, I feel good about that. It's fine. And I even mentioned at the time, I was like, the kitchen, I do not love. And the walls are, a little Pepto-Bismol. I don't love that. And by the time we got here, and I was so stressed out, and we'd bought a new car, and it was a thing. There was a long, long experience. I was exhausted. We had 6 kids, just displaced them from the only home they'd ever known. And we got here, and I looked at those walls, and I'm not even joking, I just cried. I was like, I can't with the walls. I can deal with the cicadas, I can deal with the really heavy humidity, I can deal with it starting over, but oh my gosh, not those walls, I cannot. So he painted them for me. Oh, he says, okay, stop talking. Are you ready?
The green Hethia bushes.
I will not play verdict music. Scott is standing right behind me. I like the light colors, white, cream, and gray. Yeah, those are beautiful. They don't work really well with we have brown with kind of red undertone woods, mahogany, I think. And it's gorgeous. The wood's gorgeous. But walnut stain over oak, so not mahogany at all. But it's so pretty. It doesn't work with gray at all. It just does not. They don't play nicely together. And so, yeah, it's been a thing. I finally had to lean in and say, we either go red or we go green, and I cannot do red. So we went with green. He said the gray goose. Verdict music, I don't think so. I mean, I saw somebody moving in there, but I saw the head of somebody bobbing along there. Would you like your microphone back? Yeah. Okay, guys, it has been fun. I'm deep red or teal. Actually, I found a color that I really like. It's called seafoam green, and it, depending on the light, is either green. He's pulling me away, or it has a blue tint. Okay, bye.
Thanks. Isn't she wonderful? All right. Oh, mic's hot. Okay. Turn that down. That down. Oh, the other mic was hot the whole time, too. She's a gem. I love her. She is absolutely wonderful. Who is the manufacturer for the seafoam green? Whoever. It's Lowe's. You go to Lowe's and they have seafoam green. I think it's the Lowe's brand. I forget. He had a curved shepherd stick to pull Mrs. R.A. away. We need to hear more from her. She's busy. Here's what we need. I've told her we need to go on a date. And I've set the bar really high. I suggested some things. She's vetoed all of them. But we just don't get enough time just to hang out. Just the two of us. I thought it would be great to rent like a 2-person kayak and go kayaking on the Tar River. She doesn't like water moccasins, so that sort of killed that deal. But I'm thinking something in the Greenville area like that. She suggested going to West Virginia to ride the Hatfield-McCoy trails, which is more like a family vacation. But then we would need ATVs or side-by-sides for the whole family and passes for the whole family. So it's like going to Disneyland cost-wise. So, I don't know, Dollywood. I've heard about Dollywood. My friends go there and loved it. It's just across the border. Valspar. Yeah, Valspar it is. Sherwin-Williams sea salt. Yes, but we use Valspar paint. Go on a date and buy grandbaby some stuff. We've done that. Hope Red Lobster wasn't top of the bar. Red Lobster is not her scene. She doesn't like that. Just saw some top of somebody's head in the courtroom. They are moving around. We've got live audio from court. I was hoping that they would give us an answer here soon. Have you ever been to the Biltmore Mansion? Yes. And I know that my wife also did a tour of that, like with a friend here. The lines are insane at Dollywood. Well, I'm crossing that off the list. I hate lines. I don't like watching TV shows because I feel like it wastes my time. I just don't like waiting for anything. And if there's a commercial, then the show wasn't worth watching. That's why I don't put ads in my live streams. Yeah. They might be done for the day. It's very possible. We might have a early morning note from the jury. Hearing a little bit of audio. They're bumping some of the settings, so maybe there might be some action. Asheville is nice. We have been there. It's beautiful. All of a sudden, everyone is a paint pro. I don't mean to brag, but it's the first job I ever held on my own. Well, it's my first company I ever owned. I owned a painting company. We called it Prime Painting, which we thought was quite the play on words. But realized it's really fun to own a company, and it really sucks to be the business. It sucks to be the boss because there's lots of work there. Mathis, I forgot. Mathis, I apologize. Is it too late? Is it too late, Mathis? Go on a date and visit your granddaughter. Oh. We have a... Why is she
Hello.
Hey, Mathis, how are you doing?
I'm pretty good. I just had pizza.
Ooh, what kind?
And it was
pickle pizza.
The name's probably, I don't even know how to explain that. Hollandaise, salmon cubes and spinach with like cheese filling in the crust.
Wow. Yeah, I don't think you can get that at Domino's.
I mean, theoretically.
Sounds good. We haven't talked in ages. How are you doing?
I am dealing with a lot of annoying things, but I am cautiously optimistic.
About?
The future.
Oh, good. It's good to have hope. So hopefully, hopefully everything works out well with those things.
Yeah.
You said you had some things to talk about. Is it this case or my or what?
Yeah, it's this case and some of the and so I looked at the law and there were a couple of things that really didn't sit well with me. If I can just give you
let's give a quick rundown of those.
So I think yesterday someone said, okay, there's some interesting case law, and I tried to look them up, and the more I read, I'm not really siding with the prosecution on this one.
Okay.
So, for example, there's a case called State v. Dickey. This is 2011 opinion by the South Carolina Supreme Court. The facts are basically there's a visitor to an apartment building, gets hit, splashed by a water balloon. There's apparently a prank war between neighbors. Visitor gets angry, makes threats. Someone calls the security guard for that apartment building. Security guard tells them they have to leave, makes them leave, and follows them.
Ooh. Okay.
The angry visitor is also angry for being followed. Approaches the security guard. Security guard pulls out a gun. He testifies in his own defense. He says he wanted to dissuade them, discourage them from approaching. Then he sees the guy reach under his shirt, shoots him 3 times, And the South Carolina Supreme Court said, you know what, trial court, you should have granted a directed verdict here.
Because it was self-defense.
I mean, it's a reasonable. Well, the defendant testified. He feared that the victim of the shooting would pull out a gun. That's evidence of That's element of that introduces the element of self-defense, and there's no evidence to disprove that he didn't act in reasonable fear. So now you have to go through and now when you apply that lesson to this case, if we go through the 4 elements of self-defense, I think the evidence that the state has to survive a directed verdict is kind of thin. So on the first element, you can't be at fault for causing the difficulty. I think that language is very old, like 18th, 19th century.
Right.
Some of you Americans know if South Carolina, when that became a state. I do not. I haven't been on your side of the ocean, either ocean. But basically, the cases that I looked at to understand what that means, there's something like State v. Williams from 2019.
Okay.
That talks about, well, for one way you can disprove that is if you do something illegal where you have to reasonably expect that the situation would arise. So, and I think in Williams, someone brought a gun to a drug deal.
The drug deal being illegal.
Yeah. You can, also the gun was illegal, by the way. So presumably no gun rights, convicted felon, did something illegal, and you can reasonably expect that during a drug deal, guns may blah blah. I don't fully remember that case, but that is the kind of thing that you would have to disprove the first element. That's what you would need to do to be at fault. So I look at this case and I see that, well, there's no crime alleged during for the chase.
Right.
The son was not charged with anything. He gave statements to the police that were ultimately the same as during trial, so they could have charged him. But apparently, well, the police admitted, presumably they cannot charge him if they say under oath, well, that isn't illegal. So I don't think you can really fault him for bringing on the difficulty for following a suspected shoplifter. I mean, we can change. So one thing you learn when you get a doctorate degree in mathematics is when you apply like rules-based reasoning, sometimes you're just given a set of rules and you don't like that you have to deal with them, but someone just either made them up or it just forcibly appears.
This is how I am with most board games. I'm like, oh, these are terrible rules, but I have to play by them. Yep.
Yeah. So, for example, we can, if we have a rule, well, we can try to understand the rule by changing all the other facts. So, for example, what if we can ignore that this is a 14-year-old because we can change that. What if it's a 39-year-old hardened criminal, serial killer, international assassin? It's kind of it's a Lex Luthor type. He has done every crime that. Yeah, true villain, has done every crime. He doesn't stone like a bottle of water, but it's a hard drive with $1 billion in Bitcoin and the nuclear codes. Whatever. It's as valuable as you want it to be.
Yeah.
Yeah.
It's an extreme opposite or extreme scenario.
You can just pick a parameter and says, okay, this isn't part of the rule you're pronouncing, so I set the parameter to arbitrarily extreme. So let's say you have something of very valuable being stolen. Well, is it okay? Well, for example, is it okay to confront him? You appear to have stolen something. We would like to detain you. Do you have to let him go because you could, in theory, check the video? I don't think that holds up legally.
It doesn't.
Now, I'm not athletic. I'm very out of shape, unfortunately. But I don't think that distance is like that big of a deal that they chased him. Like it's like when I walk a dog, not Corey Richards, when I walk my family dogs, I sometimes like jog substantially long distances with them.
I think the
It's not that crazy to me.
The only thing that would make the distance be a factor is if an element of the crime was property related and property ownership related, which it's not.
Yeah.
If it was leaving their property, I mean, like in some cases you can carry a gun on your own property, but you need to have a license to carry it in public off your property. That would be the situation, but it wasn't charged, and that's not the case here.
Yeah. So I think this. So if I go by the list of these elements, when I think, okay, what is the reasoning that the state is applying, I can say, okay, change the parameters to something more extreme, and I think the arguments don't really work for me. What this case kind of ultimately boils down to something very simple. You have a scenario. You are following a suspected criminal because you want to confront them, and it's a free country. There's no law that says you can't confront them. The suspected criminal pulls out a gun, or you have a reasonable belief that there's going to be a gun pulled. It doesn't have to be actually pointed. The security guard in Dickey was acquitted by the Supreme Court because he thought there was a gun because someone reached under their shirt, which could have been a water bottle that someone had like in their shorts. I think that was part of the facts of that case. You can shoot someone over suspicion of a gun when in reality it's actually a water bottle. Now, in this case,
it has to be reasonable, right?
Yeah, you have to. If someone, so in Dickey, you have someone approaching a man with a gun drawn, reaching into shirt.
Okay,
That is kind of
yeah.
If you have to make a snap judgment before the gun is pointed at you.
Cops make that judgment all the time.
Yeah.
We
If
see
this was
lots
a
of
cop case, if
it
a
would be a
cop
justified
heard
shooting.
there's a gun, the cop doesn't have to wait until he confirms the gun because you can't. Because in some situation, the way you confirm that there's a gun is when you get a bullet in the head.
Yeah.
That is the reality of why cops get away with a lot. So I'm not convinced that there's really like that powerful of a case against the defensive avarice issue. And in fact, kind of some of these arguments by the state, I could give that the same closing arguments, but evil. Because let's say you have let's say that you have someone, they might have stolen something, you don't know the value. Let's say it's some number. Make up your own number. You follow the person, and they fall to the ground. You hear your child in front of you yell, "He's got a gun." At what value of property do you realize, I should have not have chased? It's like if I act now, if I could, let's say you have this amazing decision to think in a time stop. Well, you have infinite time to think about this.
Yeah. Now you've got your son in danger, and you're
By the
asking the
time it's
question: what is the value of a human life? Talking about your son.
You have to think. Well, I'm now very upset that I chased him, but I cannot go back in time. So now I have to make a snap. Now I have to make a not only a snap decision. I have a year to think about this in my mind palace. I could shoot him, or I could risk the death of my child. Now, the law says it's unreasonable that I chased him. So maybe that means it's murder if I shoot him. So maybe it's murder if I don't risk watching my child die. That is the law that the prosecution apparently argues here. I can't spin this any other way. It's an argument that, well, you made a mistake, so now you have to watch your child die. Because you hear your child yell, "Gun?" Well, if you are a rational person, at that point, you have to decide against taking a defensive maneuver because you followed him. And you could have not followed them. So to be a law-abiding citizen, just take the risk that your child dies in front of you. That's the law that the prosecution has argued to us here. I don't like that. I think the prosecution kind of has a bad case. I think the prosecution would not have argued this if this was a police officer who was overzealous in chasing someone suspected of a crime. I think the issue is that 14 is, in terms of age, a low number, but this was a young man that's maybe taller than I am. He appeared rather tall in the video. Maybe he appears taller than I think he really is, because he's standing next to Asian people who might be not be as tall.
They were
I
bigger than
only
him.
know how
They were bigger than him.
I didn't get. I did not look at the footage that well. I'm confused by the angles. I don't know.
Yeah.
I think the centimeters ultimately don't matter. What I do think is it's a huge problem that he had a gun. That is the most outrageous thing in this story. It is a crazy problem that this child had a gun. That is far more outrageous than an angry shopkeeper chasing after someone. How is this remotely acceptable?
Yeah.
Because now I'm not part of your culture. I'm not American. I'm not a peer. I cannot judge your way of life. But it seems to me that I kind of have to give some deference to U.S. gun culture. The adults who are legally allowed to have guns, they are legally allowed to have guns. When there's no law that says you can't chase someone, you are allowed to chase that person. Free country. The 14-year-olds are not allowed to have guns. That's the law that was passed. Seems okay. I might have different opinions on, like, if I'm the legislature, I might write something else, but I'm not. If you came to Germany, there's currently a vote for the youth slang of the year 2026. And the big vote is multi-purpose eggs. In German, we don't put spaces. It's multi-purpose eggs. You're probably confused. What? In German, multi-purpose eggs is Mehrzweckeier. Mehr is more than one. Zweck is purpose. And Eier is eggs. Mehrzweckeier. This is a pun. It refers to an incident where someone called the chancellor a ball licker. Merz leckt Eier.
Mathis.
That is a crime in Germany. You can go
and on
you
the
can
channel.
be dragged in front of court.
And on the channel.
There's no jurisdiction. You cannot be brought to court in Germany for insulting the chancellor. So and you have no vicarious liability for broadcasting my indirect speech, quoting that to you. I'm reporting you legal facts. Everything's covered by journalist privilege. In Germany, you can be swatted for insulting the chancellor. Laws are stupid sometimes, but you have to take them as they are.
Yeah, we're gonna have to wrap this up a little bit. Let me ask you before you go, because and we have some movement in court. So let me ask you this question. I was not happy with what I saw when the defense at the end of their case renewed their judgment of acquittal motion, and the judge said, I'm going to deny it for the same reasons.
I was also very upset with that reasoning. It's a completely different legal standard. You have to evaluate something else.
There's another thought process that has to be evaluated for sure, and it was the whole self-defense side that was presented, because it hadn't been presented up until then. And for the judge to deny it based on the burden of proof that existed under the first set of rules, which is just beyond reasonable doubt, did he commit this, and to completely ignore has the state proven this is not self-defense side of it, I think was wrong, and I think that is reversible error. So I think if he gets convicted, that will give him an appeal.
I think so. I don't know if this defense objected enough. I don't know what the rules are for South Carolina. Apparently, from murder, we learned maybe that's murder, maybe that's Indiana. What I'm thinking of. Maybe you have to say objection a lot. The talismanic invocation. I don't know if it's preserved, but it seems to me that the judge did not apply. If he says for the same reasons, well, that's the wrong legal test.
Yeah.
But it's a very thin argument because there's not much to quote.
Mathis, Mr. Chow's back in the courtroom. Thank you for the call. You've said the forbidden words. We have to time you out.
Yeah.
It's good talking to you, my friend.
If I get swatted, I know who to blame. I'm looking at every one of you, chat.
Mathis, thank you very much. Appreciate it. We'll see you.
All right. Have a great day.
You too.
Bye.
Bye. Oh, man. I was not expecting that. Mr. Chow's back. None of the defense attorneys are yet, so he beat them back. This probably means that this is end of day. That this is end of day formalities as opposed to a jury conclusion. So looking at the time, they've deliberated for 5 hours and 11 minutes, counting their lunch time. It is 5:42 right now. They're probably going to take a few minutes just to gather together and probably wrap things up by 6, which is sort of on the tail end of when we thought they would deliberate tonight. Mathis is great. His got great intellect. His mind is like a. I think his IQ is like exponentially higher than mine. How many times has Mathis called and we get a verdict? A couple. I think he brings it in. He likes to talk at the end of the case once he's heard all the evidence, and he's had time to do research. Which, I mean, from calling from Germany to call into the program and having researched U.S. case law before he makes the call, that's some dedication. So Mathis, thank you very much. Thanks for staying up late as well. Let's see. He's a great friend of the program. He's even written a song that we played back in the day that was great. All right. Hope Laura is back just in case. I don't think it's a verdict. The reason is the jailers brought him up before anyone else showed up. So there was probably a standing order to bring him up at a certain time to wrap up for the day. Missed this whole day, Joe. This has been an interesting day. You only have to rewatch the beginning because it was closing arguments. But I would say if you missed closing arguments, wow, please watch them again. Both of them, I would all three, 2 from the state, 1 from the defense in the middle, were very unique. Defense yelled a lot. Like a lot, like the whole thing. They yelled their closing argument. Extremely passionate. There was antics, the actions that were over the top. There was a lot of, back in the day, there was reminiscing. There was, good old-timey anecdotes and storytelling involved. There was there was a lot of things that happened that we haven't seen in other trials. We've got very well-dressed lawyers. We had a battle of the suits. We've got the painted shirt comes back out again on the first closing from the state. We've just got a lot of things that happen that would be interesting to watch. Even if you don't have a side on this at all, you haven't listened to the evidence, just watch the closings, and it's quite the show. 3D chess. We've got. It's the first time I've ever seen a lawyer give a closing argument while seated on the witness stand, which I've never seen before. But defense got up there and sat in the witness chair and talked to people, and the prosecutor took off his coat and showed his, the shirt, the red dot and the black X, and we talked about this, the defense suit that has his name written on it all over his suit instead of pinstripes. I mean, that's got to be. He had custom cloth made for his suit. It was wild. When he says defense, he means prosecution. I keep messing them up. You know what I mean? I just get ahead of myself. Anyway, lots of interesting things happened in this. So if you watch the morning stream today, that's well worth watching. I'd watch the whole thing. It was not. I think there was only one objection raised, and it was by the defense, and it was overruled during the closings. So there wasn't a lot of interruption that way. And I do believe that both sides have a lot of respect for each other. They know each other. One of them said they've known each other since like grade school. But still, it's a unique show. It's got its own South Carolina flavor. It sort of feels like you're going to church being preached at, and and also, there's just, especially with defense, the way they yelled, it was like a hellfire and damnation sermon. Is what we heard all the way through. We're all gonna burn, and at one point he even told his client, enjoy hell. That was his quote from defense to his client. So there's some things in there you might want to watch and listen to. They were long. Defense was in the middle, obviously, and they took about 30 minutes. Prosecution took 45 and then 30. So, altogether, it's under 3. It's 2 plus. But closings really weren't that long. They weren't. They just felt long because we were getting yelled at, and it was sort of bizarre. Kayla Jackson that says, agreed, very good closings. All the attorneys fought very hard for that case. Very hard. This is no lack of effort at all on this one. I think this is a very interesting trial. Selena, I agree. Do you think this is a verdict? Nope. I think this is going home at the end of the day. Juliet Barnes, I don't know how long he's been in custody. I would imagine it would probably be since he was arraigned. I don't know of any bond violation situations that arose. He probably was kept in custody and has been in custody for a couple of years. This happened 3 years ago, right? Dog Mom of Two Loves says, Recovery Addict, if there is a hung jury, does Mr. Chow have to stay in jail pending another trial if there is one? I think there's a time period where they can refile and keep him in jail, but so I think he would stay in for the short term. They won't just let him go today because it was a hung jury. They'll say we're refiling, they'll do the paperwork to keep him in jail immediately, and then they'll make the decision. We have some pretty lakes near Raleigh, like Lake Johnson or Lake Wheeler, that you and Mrs. R.A. can rent canoes and just walk around. Isn't there like a Daniels Lake or something over there too? What's the one just south of Raleigh? That's a big one. I've been there once or twice. I can't take her fishing though. She doesn't want that. He's been in jail since he got arrested. It was this judge that denied his bond? Juliet Barnes, I'm glad I saw your question. Happy to try to answer him. I voted for a verdict tomorrow, but I always get it wrong. Well, Camilla, it looks like you've got a better chance than those of us who thought it would be sooner. Wasn't he arrested 2 days after the incident? I think it was fairly soon thereafter, yeah. I heard the rumor that they thought he could be a flight risk. Well, he's definitely not on public defenders. I think he had resources, financial resources that could make him be a flight risk. Gold Gavel says, I totally get not letting the jury know about previous bad acts, but I'd be so mad finding this out after the trial. I have to challenge you on that, Goals Gavel. First of all, that is a really good looking gavel. It looks a lot like mine. Let's right here. I have to challenge you on that because bad acts would have to be a crime, right? You can't have a bad act be helping an old lady across the street or winning a Medal of Honor award. If he used his firearm previously in self-defense, and it was ruled that it was self-defense. Looks like everyone's come back from chambers. They were all in chambers with the judge. And he's got a note. They may be hung. They're explaining to Mr. Chow right now.
All right, counsel, just so we're clear on the record, we gathered in the chambers. We let y'all know that we received another note, which I believe also contains some of the deliberative process of the jury, which I'm not comfortable disclosing within, basically consistent with South Carolina law. It's not. So I'm going to, and I can say, mention that at least some had indicated they may want to go home for the night. I'm not inclined to do that. This case has garnered a significant amount of media attention. I would be concerned that the jury could somehow be compromised or researched or something. So now that we've started the process, I'm going to ask them to push on through and go ahead and order dinner. Any objection to that from the state?
Negative. No, we concur.
Okay. All right, bring him in, please, sir. Yes, sir.
The jury wants to go home, and he said no. I've never seen that. The judge is concerned that they're going to see media attention, and that's a valid concern. Defense raised it this morning. Even asked to have the, almost asked for the jury to be sequestered. But they want to go home, and the judge said, we're not going to do that. This could be seen as forcing the jury's hand or telling them they have to reach a verdict in a certain amount of time, which under South Carolina law is a reversible error. I'm fine with the jury working overtime, but forcing them to work overtime is a different story.
I have received your note. I understand some folks may be getting fatigued. This has been a long day, long week. Typically, once the deliberative process begins, we ask you to stay here as long as possible. Certainly, we're not going to do anything inhumane. But I'm going to ask you to keep deliberating. The clerk is going to get with you shortly with regard to orders for dinner. And we're just going to ask you to keep working. I understand it's been a long day. It's been a long day for everybody. And I know y'all are diligently working, and I appreciate that. But we're going to ask you just to keep working, and we'll get your dinner orders, and we'll just let us know if you need anything else. All right. Thank you.
There's a valid concern there. Right now, more than any other time in this trial, if a juror is exposed to outside influence, it could be a major problem.
Any objections from the state?
Negative.
Negative. All right. Thank y'all. We'll let you know. Hey, yes, sir.
I don't know why the state did not stand for the jury. That seemed a little disrespectful. Just a little bit. Just a little bit, but they all remain seated for that. Mr. Chow, remaining in cuffs, will be put back down in the holding cell. He's going back and forth to that holding cell in the courtroom. I can see the reason for this, especially because of the media coverage, because of the fervor, because of the attention that's on this case. The risk that these jurors going home now at this point could be directly influenced or impacted in their decision-making process during the deliberations is very high. And one way to make sure that doesn't happen is keep them here, but you can't keep them here forever. And that fatigue, that exhaustion, unless they were notified beforehand that, the judge said, we're going to go these hours from here to here, from here to here. Unless they were notified beforehand, there may be obligations that you're keeping the jury away from. Family obligations, childcare obligations. Work shouldn't come into it because they shouldn't be working at all when they're on the jury. We've seen that in other cases. But let's see. Hang on just one second. I think we have Twin Tail. Where am I at? There we go. Trying to join voice. There we go. Twin Tail Fox, welcome. How you doing?
Hello, hello.
How are you doing?
I'm good. How are you?
I was pretty sure I was going to play the music and wrap things up for the night. And now it looks like we're here for the long haul. So I'm thinking about what we're going to talk about.
Yeah.
What do you have?
So, from the call earlier where he was like, "Oh, I'm European and this is that." It got me thinking, like, as a European, when I heard that Cyrus had a gun, I was absolutely blown away. I was so shocked, but then it sat with me that he is in the USA and it can be a dangerous place. So it kind of like, I understand why he had a gun, but he shouldn't have a gun.
It's a dangerous place because we have 14-year-olds with guns.
Oh yeah, definitely.
That's part of it.
And like me being like in Iceland, like I am in Iceland, one of the safest countries in the world. Mm-hmm. So me thinking that a child has a gun, it blows my mind. It's insanity to me that the kids have guns.
But honestly, I mean, just watching someone, if you came and visited, and I introduced you to my neighbor, we'd have a whole conversation, and he has a gun on his hip the whole time, and for me, it doesn't even bother me in the slightest. I hardly even notice it, but it might be very different to you. Like, why is he a police officer? Why does he have a gun right now? It's a very
that is absolutely insanity to me that you can just carry a gun with you, because here in Iceland we have gun laws. And the gun laws is so strict that if you do not have your gun like locked in a safe, you can like lose your license, and the police have full control to come into your house and take all of your guns, and you will never be allowed to have guns again.
I would say it's really hard to use a safe in self-defense. They're heavy.
Oh yeah,
they're difficult to carry, and it's hard to get into.
And also, to get your gun license, you have to talk to a therapist, you have to meet a doctor, and you have to go through a test to see how good you are with a gun. Because if you fail any of these, you will not pass to get your gun license. And you have to renew it every 2 to 5 years, depending on how good your mental health is. And if 1 year your mental health is bad, they will revoke your license, your gun license. And then you can take it again a few years later, and then you can get your guns back if you pass.
Yeah. Yeah, it's definitely a different mindset. I think we're the same, that nobody thinks that it's a great idea to have kids with guns, right? That's not okay. But the guns themselves, generally speaking, are a big part of our lives. Not that we every day someone carries a gun, or we after at lunch everyone goes out and shoots and practices their aim. Doesn't. It's probably been years since I shot last. Well, at least a year since I shot a gun. And
I mean, I have shot a gun. Like, I went to a controlled environment to shoot guns. And that was like, oh my God, I'm actually holding a gun. But there, it's just so normalized, and you can get guns everywhere, and it's just, it's absolute insanity to me.
It's a different mindset.
I find it so sad.
It's sad. The sad part is we've got a child that's passed away now, that's been killed, and it didn't have to be this way. Right? This was not lightning struck and it was an act of God, or there was an earthquake and a building fell. There was nothing we could do about it. This was preventable on many different fronts.
Oh yeah.
And we can say, society-wise, it was preventable if we had, had, better role models or more support, or, there's a couple things, a lot of things we could do there. And then on the Chow side, there's definitely some things they could have done that could have prevented this from getting to this point. It's terrible we're at this point, and I wish we could address all those points so this doesn't happen to any other family and any other kid.
No.
But one of the things we need to address is 14-year-olds with guns.
Yeah. But I do have to admit, there has been a lot more violence now in Iceland after, like, our borders are wide open. So, yeah, there are, like, just
there are challenges.
More gun violence, and then people getting stabbed and stuff like that. So, like, we are slowly getting all that. Yeah. But I'm so glad we still have this strict gun safety, because I would not like to think what would happen if we would have guns on the street of Iceland. That would absolutely be terrifying.
Well, it's when people got drunk, they'd shoot at the Northern Lights. That's what would happen. I'm sorry.
Not be surprised at that.
It's beautiful up there, by the way. Beautiful. So
it is, especially this time of year, because the sun does not set. It's absolutely beautiful.
Now
we have sunlight 24/7.
I've got a friend, actually my co-business partner that worked in our Airbnb with me, the friend that helped me with a lot of my projects around my house. He just moved to Alaska, to Barrow, Alaska. And
ooh.
That we say Barrow, Alaska, but he's actually on the northernmost town, like on the very north. He's at the top of the world. Yeah,
oh, wow.
And he's going to live there for the next 5 years. And his wife is a traveling nurse, and she's a nurse up there, and they love it. They absolutely love it. He's, he has to wait for a year before he can hunt caribou, but I mean, they live in areas where people bury things in their yard. They have a big pit dug in their yard and permafrost, and that's their freezer year round because it's always frozen. There are polar bears around and snowmobiles, and it's just crazy. It's a different climate. And up there, I was watching a video. There's a YouTuber who went up there and just spent 3 days living up there, and it was funny because my friend said, yeah, some of the video he showed, I was at that little concert that he was filming and things like that. 5,000 people in this town. But one of the guys said, up here, hunger knows no laws. Survival is the rule. And yeah, we're part of the U.S., but we eat to survive. And they do whaling, and they save, dish out the whale to all the people so they can survive, and that's how they subside during the winters through this whale blubber and fat and everything. It's a little different. The culture is just so different up there, even though it's part of the U.S. that it's just crazy. It must be similar for you looking at us. Wow, you guys guns? Why do you have guns?
Yeah,
but it's just
actually. Yeah, it's actually funny that you are talking about like cultures in this like same country. Here in Iceland, the north and the south are so different because in the south, in the winters, they barely get any snow, like no snow in the capital. But where I live, we have snow that reaches to my roof. Like the cars get buried, people can't go to work if the roads are not plowed. And I'm snowed in almost the whole winter. So I have to be very careful of what I buy to stock up in the winter. And like, it's survival of the fittest in Iceland in the north. But in Reykjavik and in the south, they're like, oh, like there's no snow. You guys in the north are just whiny babies because of and like when there's a big snowstorm here in the north and everybody gets snowed in, nobody will talk about it. Absolutely no one will talk about it. But if it snows in Reykjavik and they like get into like crashes because they don't know how to drive in the snow, they will be whining for days
That's funny. That's
So-
funny. Yeah. We have a lot of people where we're at. My family lives a little differently. We go shopping every 2 weeks, right? And then on the off week, we'll buy a couple items that we need. So one shopping trip will last us for 2 weeks, and then we have stuff on hand in case we can't go for a few days after the 2 weeks are up. We can still make meals and eat and everything else. There are other people who their culture or their norm is you go to work and you hit the store on the way home and get what you need for dinner and breakfast and lunch. And then you go to work again and you do it again. And whether that's, just subsistence, just at that level, we can't afford to buy in advance, or if that's just a lifestyle choice, that's how it is. And then a hurricane comes along and people panic. Like we might be flooded out for 3 days and the stores get emptied. Bread, milk, beer, toilet paper, it's gone. Like Sam's Club, the big box stores, truckloads of toilet paper get sold right before a hurricane because people are panicking that there's going to be, the storm's coming and the power might be out for a little while. So,
oh my God.
It's fun.
Yeah, I'm all because I don't have a car and the next village is 15 minutes away, but the main town I go to is 30 minutes away. So I always have to stock up, and I'm so used to just buying for the whole month. So I don't have to go shopping for a month. So when I hear people that are like, oh, I'll just go this week and buy for 1 week, and I'm like, why don't you just buy for the whole month? It's not that difficult.
I watched a YouTube video of this couple that live way off grid. I think they're in the middle of the tundra of Canada or something, or maybe it's Alaska. I don't remember.
Ooh.
But they're like, this is the month. We're going shopping, and it's a huge deal. And they've got to get all their coolers and everything, and they haul the trucks, and the neighbors come and help, and then they get on the train, and they ride the train, and then they rent a truck, and they ride the truck, and they drive for 6 hours. They get to the store, and then they drive. They buy everything. The truck is just piled to the top, and they have to carry this all back and load it up in the freight and the cargo on the train. The train just stops in the middle of the wilderness. They push it off the side, and they have to drag it to their. It's just wild. I can't imagine living like that. But
yeah,
it
I would
sounds
say stop there.
Yeah, that's normal. So.
Oh my God.
Tell me something interesting and fun.
Something interesting and fun. I just dumped a guy. We were in the talking stage, and I decided to dump him. So yeah,
Twin Tail Fox is
that.
Available for all you young men out there who might be single. I'll sell her number for the right. No, just kidding. You're good.
I'm also. I have been teaching myself to weave, so hopefully I will get something done
Is the
soon
loom
to show you guys.
up and functional?
Yes, it's up and functional. My cat decided to try to chew it, so I had to fix that.
It's a lot of string for the cat not to be able to play with.
Oh yeah. Also, the cat decided to give me a heart attack. He decided to throw up and then become half paralyzed and half seizing in my lap.
Oh wow!
But then he is okay. And then he had to have a cone of shame for 2 weeks because he has a wound on his head because he is allergic to himself and likes to scratch himself to blood. So we have been dealing with that, and now he is finally back to his energetic self after giving me a heart attack.
Now, when you mentioned the cat, we found a YouTube channel. My life revolves around YouTube, if you can't tell. We found a YouTube channel that's like a cat sanctuary, and there's probably 50 cats, and they've got cameras. They have more cameras than Chow has in his grocery store, his gas station. They've got cameras everywhere, and just piles of cats, boxes of cats, and they're walking and climbing and jumping all over it. My kids loved it. They loved watching that. And then, of course, today they had my wife take them to the pet stores. They could check all the cats that are there for adoption, so they get to pet all the cats. We already have half a cat, so anyway.
Yeah, also I was very lucky to wake up this morning because it's the first full day that my cat has had the cone of shame off.
Mm-hmm.
And he decided that he would barf up a hairball in the morning, so he was able to wake me up with that. So Oh, well, good morning. I made hot chocolate with the Recovery Addict
Stevens hot
cup.
cocoa? Oh, the cup's great.
No, with
But you should try
yeah, I
Stevens
love
hot
the
cocoa
cup.
mix if you can get it in
We
Iceland.
don't have that in Iceland.
It's so good.
Sorry.
It's so good. It's
Iceland is very. Last year, say it's sad
you
what
have like
we have
Swiss
available.
mix. Swiss miss.
Yeah, I have that. Yeah.
That's like dirt. It's like adding dirt to your chocolate, compared to Stevens Gourmet hot cocoa. So maybe we'll have to figure
Yeah.
out a way to get you some. So. Well,
Yeah,
Twin
we
Tail
can try to
Fox.
figure that out.
All right. Thanks for the update. It's good talking to you, and we kept it clean. I'm not embarrassed about anything, so that's the way we
Thank
like
you
these
for
calls
letting
to
me
go.
vent a little bit.
Thank you. Appreciate it. Talk to you again soon.
Okay, bye.
Bye. All right, wonderful. Hot take. Yeah, Swiss Miss now never going to be a sponsor. All right, so here's what we know. We're still staring at the wall here in the courtroom in South Carolina because the judge, when he got a note from the jurors saying we'd like to go home now, we're a little tired, he said no. Keep working. He does not want this jury to go home. If they do, there's a risk that they can be exposed to social media or news or someone who's seen social media or news regarding this case and might get someone else's take on the story. Maybe someone who they respect or love or think highly of. And if they hear that, it might cause them to deliberate differently. So the judge does not want anyone going home. And we're here for as long, he says, we're not going to be, unreasonable about it. I'm not going to keep you, torture you here, but we're going to feed you dinner and ask you to keep waiting. So we might be on here for a little while. We might also, let's see. If I shut off the live stream, that's usually when the verdict comes in. But, let's see. We'll leave us with cat videos while we wait for the verdict. Basically, he doesn't trust the jury. Tai Chi Lemur. Yes. This is basically the case. Carol Racine says, I bought Stevens hot chocolate because of Aria's recommendation. It's so good. It is delicious. They just do it right. It's the right mix. So they have to stay there till they're decided. The news isn't going to go away tonight. Yeah. I don't think they're going to reach a verdict tonight. I don't know. The judge knows something we don't, right? He knows the numbers. It sounds like the foreman has given them information about deliberations. And I don't think they were told not to. But he can't tell the lawyers that. But he is aware of sort of how the deliberations are going, which I don't think he should. Because that would definitely influence. For example, if the foreman came and said, look, we're deadlocked 6-6. We're split right down the middle. Half of us think he's guilty, half of us think not guilty. That would probably not be a situation where the judge says, well, so let's stay as late tonight as you possibly can, as opposed to we've got a holdout. You've got one juror who just isn't there yet. Then the judge's like, yeah, keep working at it. You're close, right? I don't like it, but I can see the necessity. Stevens is not available in Canada. I'm so sorry. You're going to have to schedule a trip down here. Doing what the judge has done can also cause the jury to make a decision they might not have made. That's where the South Carolina Supreme Court rules come in that say you can't sort of force the jury to make a decision in a certain timeline. They will not retry, in my opinion. Can a judge be held accountable for holding people against their will? Yeah. Nope. He's protected. Unless he does something really illegal. What if the judge brings in s'mores? They're yummy. Don't think the judge is allowed to know. I don't think he should know. And this is the second note he's had with this information in it, which means he didn't tell them not to on the first one. It's a bad deal.
Call from Allison.
Hey, Allison, this is R.A. How are you doing?
So I had a couple of comments, but really I just want to say, why don't you give a couple of us what we can call your burner phone, give you a break, and we can watch the trial on another channel, and send a message. Give you a break, go eat dinner.
I ate my dinner
hang
already.
out with the family.
Mrs. R.A. talked for a while. I'm fat and happy.
Well, go massage her feet for a little bit, and
what
we can
happens
text you,
I
give you
start
a little
massaging her
notice.
feet, and then I lay down to get more comfortable, and next thing I know, it's morning. And
Look, her raising 5 kids, and I know you did too, but that's just amazing. I can't even imagine. So you need to massage her feet for about 20 more years. It'll be good.
Yeah.
It'll be good.
Well, she's here. She can hear you.
But anyway, oh, hey. But yeah, I mean, we can text you, but I know you like to stay on anyway, but you get a break. You've been on all day.
Let's see.
But you can put a shout out for it too. So that's all.
This
I
stream's
wasn't
only
going
been
to
4
bog
hours,
you down.
so we're okay with this one because we took a lunch break. If we had been on without a lunch break, because it did take about an hour and 20 minutes off, hour and 30 minutes off, so I'm feeling okay right now. But we'll see. I might threaten to go off the air, and that's usually when the judge comes back and the jury comes back with the verdict.
Well, maybe you should do that like a rainmaker. Maybe it'll cause it to happen a little bit. So I just wanted to I forgot to say yesterday that Mathis, wanted to say, I wish Mathis would call back because he tells the best cat jokes with dry humor. He cracked me up one day, months ago, I think. So
yeah, he's got
a little
some good
disappointing today, but maybe next time.
Yep. We need Phil to call in as himself. TYO Toys. You've gotten the burner number. Give us a ring. Alice and I agree.
Yeah.
It's wonderful to talk to you again. Thank you very much.
Yeah. So I'm going to let you go.
All right. We'll see you.
I'll talk to you next trial.
Yep. Bye-bye.
Thanks. Bye.
My cat's currently busy chasing an insect that I can't find, so I can't join. Let's see. I believe that keeping the jury is meant to prevent the jury from being prejudiced by people that hate this guy, but I see how it could also hurt him. I think the way it would hurt him is if they've got a couple, a handful, 1, 2, 3, something like that, jurors that are saying, I'm not guilty on this one. I've just thought about this all I can, and I just want to go home. We'll start again tomorrow. My brain's done. I can't argue this with you anymore today. And the judge says, you can't go home. You have to keep doing this. Are they going to throw their hands up and say, fine, whatever.
Call from Amanda H.
Amanda, how are you doing?
Hey. Oh, I'm great. Getting ready to go to big town of Bentonville, Arkansas tomorrow for work.
All right. What's in Bentonville?
So it's Walmart's headquarters there, and they have their shareholders meeting. It's a big. They invite anyway associates there and big management, and our client Ken's Foods, which is Sweet Baby Ray's barbecue sauce, is going to have a booth there where they're giving out barbecue sauce, and they special requested me to go so I can talk to the big wigs and stuff. So I'm kind of excited.
So there's probably going to be about a bajillion people there.
Yeah, they're expecting, I think, between 1,500 and 2,000 people.
That's a lot.
Yeah, it is, but that's okay. I can talk.
That's cool.
So what I called for
barbecue sauce. Is it Texas style?
So it's Sweet Baby Ray's barbecue sauce.
Love that.
Yeah,
That's
the
good
best.
stuff.
Best.
Are you like a brand ambassador for Sweet Baby Ray's?
So I am an outside sales rep. I do for Ken's Food, which is Sweet Baby Ray's barbecue sauce and Ken's salad dressings. And then I do Campbell's Foods too.
Oh, you told me this.
So yeah,
I
do. And I go Walmart to Walmart to Walmart. I go anywhere between 20 to 25 different Walmarts a week.
And you just straighten up the shelves and you're like, look, sell more.
That's the last priority, is straighten up the sales. It's basically trying to get them to place orders. Like right now, obviously, at least here in Texas, it's barbecue season. Well, here in Texas, every day is barbecue season, but this is prime barbecue season because of the main holidays, Memorial Day, 4th of July, Father's Day, etc. Getting them to order the display quantities if they weren't getting it forced out to them, and just stuff like that, and then selling in, and then we worry about stocking shelves and stuff. So it's a lot of fun, and it's never the same because, Walmart is never the same because the people are always fun to watch. So that's my favorite part about it.
Well, what would it take for you to also be a sales rep for Pepperidge Farms?
Well, Pepperidge Farms is actually part of Campbell's.
So if I were trying to get like those limited edition Pepperidge Farms crackers, I'm not talking Old Bay because that's sort of become the norm, but like, when they do like a limited edition flavor, would you be the person that I call to make sure some fell off the back of a truck and found their way to my post office box? Is that the...
Usually I am one of the first, because I'm in so many stores, I usually always can find them. So yeah, just let me know. And if I have them in any of my stores, like I said, I've got a total of 28 different stores across DFW.
Wow.
So I can generally find them. So right now they have the butterbeer, the Harry Potter butterbeer goldfish.
Ooh, never tried those.
Okay. Well, I'll have to when I get back because I'm not going to be in another Walmart until I get back next Friday. Okay. I'll have to get you some and I'll ship them up to you.
You probably didn't call to talk about food.
No, I didn't, but that's okay.
What's on your mind?
I called. I had jury duty last month, and I hadn't had a chance to call and tell you about it. So it was a civil trial.
Okay.
And it was 8 hours of voir dire.
8?
2 defendants. Yes, there was 2 defendants. Whoa. They were together, but they were trying them separately.
Okay, so at the same time, but they each had their own attorneys, so it sort of doubles up the defense questions. It's a fun scenario. It's sort of like a mind game.
It was fun. 8 hours of voir dire. So the scenario was, defendant's truck broke down in the middle of the highway.
Mm-hmm.
Did not turn flashers right. Lost complete power. But instead of calling 911 or anything, they called somebody to come give them a tow. It's dark outside. No power, no lights or anything on the truck. The plaintiff runs into the back of the truck, lost both of his legs in this wreck. So, like I said, it was civil. Sorry, my dogs are starting up. I got to get the water bottle. Anyway, so it was civil, and of course, we all sided with the plaintiff on this because that was irresponsible of them. They should have at least called 911 or something to get a police officer to get flares or something out there to, block the truck. If you can't get it off to the side and it's in the middle of the road, they should have called somebody a police officer.
Yeah, that's super dangerous.
Yeah. So this guy's life literally did a total 180 in a matter of minutes driving down the highway. And it was for $150 million.
Whoa.
Yep.
Wow.
That's what I was leaning on a little bit more. Now, the judge told us there was no way we would ever know how this was going to get paid, if it ever got paid or anything like that, which, we don't know if there was insurance or anything. Like, none of that information we were able to know. But that's what, there was 12 of us, and that's what was decided. And I was leaning more towards 75 to 100, but other people were not. They're like, it changed his whole life. He's in his early 30s. He's still got a lot of life ahead of him and having to, remodel his house and all this other stuff and depend on somebody, because he can't walk now. But lost both of his legs, almost completely up to the hips.
That's crazy. That's wild.
But yeah.
Wow. So as far as jury service though, how did all your fellow jurors, did they enjoy the process? Were they seasoned veterans when it came to serving on juries?
There was one that, because they'd ask, one of the questions they ask is how our opinion on jury services. I was like, I think it's great. It's great. It's our civil right. It's our duty to do this. And most of them were kind of like, him hawing and stuff. But one guy, he's like, I'm going to get chosen. He's had it 3 times. He's been chosen. But nobody else really disclosed that they had been chosen before. And I had been chosen one other time on a 5 pounds of marijuana possession charge that was for personal use.
So, personal use, yeah.
Yeah, personal use, 5 pounds.
That sounds about right.
Yeah, but it was, the judge was awesome. I really liked the judge because when we first got there, she was very, very good at explaining a lot of stuff. I mean, a lot of it I knew, obviously, from being on here basically every minute you're on. So I knew a lot of it, but she told us some history about this. Is one of the oldest, the one I was in was actually one of the oldest courts in Tarrant County, one of the first courts in Tarrant County. So it was kind of interesting to learn a little bit of history about the court itself. But the judge was really good. The both sets of attorneys, well, I guess all 3 sets of attorneys were very good. Questioning was kind of, didn't drag it out. Obviously, the plaintiff, he took more time questioning than the defense did. But yeah, I mean, I enjoyed it. It was a very good experience.
Did you find it frustrating when you kept getting asked to leave and then things were going on, then you're brought back and you're like, what did I miss? Did that happen much during the trial?
It happened twice, which really was not bad. It was a 5-day trial. So it was one of those things like, being that I watch from this end that we watch it from, and we see everything that's going on behind the scenes, I'm like, I want to know, more than like the average juror, because most people, probably nobody else on the jury, sit and watch trials like I do, So me, I'm like, okay, what is it? Did they try to go with something that was not supposed to be talked about, or But everybody else was just like, hey, I'll go to the bathroom, walk and get a drink or something. But But yeah, it was actually a really good experience. I enjoyed it.
That is awesome. I'm super jealous as well. I wish I got the chance to serve.
I have to wait 2 more years before I can be called again. I'm like, can I just volunteer to go every year?
There's a way to potentially get around that. You just have to move.
Really?
You have to move to a new
just
county.
Move every year?
But
now, if I just change my apartment number, would that count as moving and I could just keep updating it back and forth?
I think you need to switch to a different county. So if there's like an apartment in the same unit that's across the county line, I would switch back and
You're
forth.
right.
That's about it.
Yeah, unfortunately, I'm smack dab in the middle of Tarrant County, so that's not going to work.
Well, Amanda H., that is just awesome. I'm glad you got the chance to serve, and it's just a phenomenal experience. And thanks for representing the duty in such a positive way.
Yeah, it was very, and nobody on the jury sat there and was like, I can't believe I got picked, kind of upset, or you know how some people are. And we had really, really, really comfortable juror seats. They were like the high back leather padded. Yeah, they were really nice.
That's why.
And I thought of you sitting in those chairs.
If you had a hard bench, you would have been like, I'm out of here. This sucks.
Well, the 8 hours through voir dire we were sitting in the benches that the anybody that came in, the spectators sat in, and they were hard and miserable. And I was like, I don't even know if I'm going to be able to walk when I get up out of here because these seats are so hard.
Yeah. Did he take notes?
But we did not take notes.
Okay.
No notes.
And it wasn't a problem? Everyone remembered things?
Yeah, no, everybody seemed to remember everything. A couple of, little things like, well, did they turn their flash hazard lights on? They're like, no, they had no power. They couldn't,
Yeah.
But for the most part, everybody kind of remembered, and if one person couldn't remember, somebody else remembered, and they're like, oh, okay, that's right,
Yeah. That's fascinating.
Very good experience, and can't wait to do it again. I was kind of leery because it was a civil case.
When are you going to write your book?
A good one. Right. I'm too late now. Darn it.
Did the attorneys come in and talk to you afterwards?
They did, and just kind of questions like just why we went one way over the other, and the amounts, and it was like $150 million. That's a lot of money.
Yeah.
That's a lot of money, and basically they kind of why we decided to go with that amount. And it was like, this guy's whole life has changed in a matter of seconds because of irresponsibility. Yeah. He basically had to remodel his whole house. Most houses aren't equipped to be able to go into a bathroom in a wheelchair or get in a bathtub. His whole bathroom had to be remodeled. You can't go into your bedroom because the door frames aren't wide enough. So, I mean, his whole house had to be remodeled.
One more question before we let you go, Amanda.
Uh-huh.
What are you going to spend all that jury pay money on? Have you been saving it
I
up for?
know.
Is there like a special something you've been keeping your eye on?
Well, so we got $20 a day.
Ooh wee!
I know, $100 is what I got. You know, and you know where I went? I went and bought some groceries.
That's awesome.
You know,
a
like,
loaf of bread, a
I
gallon
went
of
and bought
milk,
groceries, you know?
a dozen eggs, and it was
That's
pretty much
about
gone.
it.
So
That I wouldn't put gas in your car, you know. But I also did the paid parking, so that was $10 a day. So that took out that's 50. There's half of my 100.
you almost paid for the opportunity to serve.
I know, right?
Wonderful. Well, Amanda, it's awesome that you were able to share that with us. I'm glad you had a good experience, and that's a story you can tell a lot of people down the road. So,
Yeah, and I had seriously contemplated because the Carmelo Anthony case, you know, jury selection started today, and it's actually over near where my brother lives.
Yeah.
And I had contemplated taking a week off of work to go over there and kind of sit in and watch that. But that judge is being such a stickler, and I mean, he's being hardcore, but there's a whole lot of behind.
and there's
that's
no media.
ugly.
There's no live stream there.
Right, no live stream whatsoever. He's, from my understanding, what I've read about this judge, he is not in favor of live streaming. But there's more I've thought about it with everything that's going on, because trying to stay out of, say Pickles, but a lot of discrimination, racism and stuff going on. And I just didn't want to subject myself to something crazy happening and being in the parking lot or something like that. So I decided it's just best I'll watch for updates that people post online and Twitter or something like that, because it's just not worth it. I mean, that school that it happened at, my daughter actually cheered a football game at that stadium. So I know exactly where it's at and all that. So
that's crazy.
But I decided it's best to stay home. But
give yourself a
I'm going to
break.
wait for another big case and use my PTO and find a case to go watch for the week.
If only there was a job that would pay you to watch court.
I know, right? Can't imagine a job like that. Tough.
I love it. I absolutely love it. Well, Amanda,
I can imagine.
Thank you very much. It's wonderful to talk to you again.
Thank you. You have a great rest of your day.
You too. Bye.
Bye-bye.
That is cool. Wow. Neat experience. I'm jealous of all you people who get jury duty. There seems to be every week there's somebody who's like, guess what I got? I got a letter in the mail. It's pretty cool. Let's see. All right. I checked. They're legally required to help you get your medication somehow. They would ask if someone could bring them. Worst case, an officer or bailiff would escort you home. Yeah, you need medication as a jury member. They can't keep you from it.
Remember in the beginning when we started 110 years ago?
Our parking is free right now because our meter reader switched jobs and they never hired anyone else. Where are you at? Hello. That's funny. Apparently they have an opening. Let's see. Sign me up. Would love to be able to do jury duty. I should probably check my mailbox, Jody. That's usually where they show up. I've never been summoned, yet my husband has twice. I've got family members who are not U.S. citizens, and they get summons, and I don't. Been 64, never been called for jury duty. Weird. They never put a job opening out. Got called for jury duty 1 month after I turned 18. Oh, man, Laura. They had their sights set on you. I feel like this may be coercive. Or it may be. Who controls the master jury list? I think, Lois, most counties, they'll either use driver's license registration or voter registration, which sometimes is sort of linked to getting your driver's license. But that's usually how they get you. I think there are a couple of counties that do some other ones tied with utilities and property ownership and a bunch of other things, but they don't want to just have people who own homes. So I think they draw from multiple lists to make sure they're getting everybody and then reduce the duplicates. So the jury a couple of times in this courthouse. Kristen, wow, that's crazy. Husband was on a grand jury. That would be neat. I got called once, but they seated a full jury before it was my turn. So disappointed. Does a grand jury have to unanimously return the indictment? I have very little information about grand juries. Sent a notice for jury duty twice, but I was excused both times. Texas is done by voter registration. What exactly is a grand jury? How do you get on one of those? Well, it's a fancy jury that basically when you get arrested and you're working through the court process, there is a point where you can have a preliminary hearing where the court is going to hold a hearing where they hear the evidence or some of the evidence against you in a sort of abbreviated, sped up fashion and determine if there is sufficient evidence to actually hold you over, bind you over for trial. We're going to have that for Tyler Robinson here in a month or so. He's got a 4-day preliminary hearing. The media is going to be there as long as it doesn't get pushed out with some of the delays the defense is throwing up. But we're going to hear a lot of the evidence against him, and the judge is going to rule, most likely, that there's enough evidence for this to go to trial. That's usually the way it goes. There's another way to go around that skips the evidence going to the public, and this is what we saw in the Brian Kohberger case. Brian got arrested and held in jail. While he was in jail, a grand jury was convened, which is a jury, just like a regular jury, only they have a hearing where they are given evidence only by the prosecution. Defense don't get to say anything. And then the prosecution says, we'd like you to, find them, issue a bill of indictment, and indict them on these charges. So it skips the preliminary hearing in that process, and then it would go straight to scheduling for trial and all the pretrial stuff. So it's the two routes that can get to the same point. The grand jury is secret, oftentimes sealed, until either the end of the case or at a certain point during the process, that grand jury information is sealed. But the big issue with grand juries, and you'll see it a lot when you get information about what happened during a grand jury, is the prosecution oftentimes has incomplete or incorrect information early on in the case when the grand jury is seated. And so there may be allegations that are made that are completely wrong, statements that are made that are completely wrong, and you just get one side, but they get to paint the picture, and they're the only person talking. And oftentimes a jury will indict based on that. And then when it goes to trial, the defense is like, "Whoa, look at this indictment! Look at what happened in the grand jury. This is wrong. They shouldn't be able to say these things that weren't true to get to this point. Yet here we are." Let's see. I was on the grand jury for 3 months in Dallas in 1994 during the OJ trial. I would run home and watch the trial I had taped on VHS. Here in Washington, we can register during change of address with post office. It's not out of the norm for jurors to stay. I would think the judge cleared it with all the jurors before making that decision. I hope so. My mother-in-law was on the grand jury, and it lasts months where they voted of different things, a lot of local stuff. So multiple cases. On a grand jury, you have about 30 cases in one day that you have to make decisions whether it should go to trial or not. When we moved about 6 years ago, I received a jury service letter, but due to COVID having started, it was canceled. Britt P. says, I've told you before, but I served on a grand jury for a 6-month term in my county. We met once every other week. It was cool, but exhausting experience. Grand juries last 6 months here and 1 month jury trials. In Ireland, we call lawyers solicitors. We have some words for lawyers, too. I'm just kidding. That was funny. I've got a good friend who's the defense lawyer here in Greenville. Federal grand jury on my friend was 6 months, but like once a month or so. That sounds pretty neat. I'd do that. Julie D says, how's the trial? I hate it when the work gets in the way of my trial watching. This is a hard trial, Julie. It's hard because of the facts and the result, the situation, especially knowing that it was avoidable. And, you know, arguably everybody in this case could have avoided it. Like a very simple action that, you know, could have prevented this from happening. So it's hard to do that. I'm highlighting chats, but they're not showing up on the screen. Seriously? I've highlighted every single one of your chats, people. Every single one. I'm sorry. I missed a bunch of super chats as well. Shelly Small. These were from Mrs. R.A. back here. I think she got all these ones. Sloth Life, thank you for that. Joy, got you as well. Love my grandkids. OG, 37 months. Stacy NYC. Do we know the jury makeup? No, but I think there's some older people represented. By older, I mean experienced instead of young, new adults. Does the jury know he shot 2 other people? No, they don't. He shot at 2 other people. I don't think he hit anyone. He hit one car in one case. Josh said you may get a strike. Yeah, about that. So far, so good. All right, I'm going to put things on the screen now. You know what I did? I had turned it off because I was showing you the camera on the printer. And people asked what I was printing, by the way. What I'm printing is nothing. My son is printing the parts to build a glass frame enclosure around my 3D printer. So we got the 3D printer, we got the glass for the kit, and now you have to print the parts to build the frame. And so it takes like 3 spools of filament to print it all. And I think total printing time is something like 47 hours of printing to print all the parts. Loves True Crime says, I'm getting there, 4 months. That is awesome. Jack from North Cackalack gifted a membership. Jack from North Cackalack. Did I say that right? I love it. Are you you're wearing a headset? That looks like a very nice headset, like a sportscaster's headset. Is that what it is? I'm curious. What kind of 3D printer do you have? I have Bamboo Labs. I like Bamboo Labs. We got a ADX5, which is hold please. Let's see where it is. FlashForge, that's it. It's still printing right here. You can barely see. All these parts on the ground are parts he's already printed. He's printed just a ton of parts. Well, you can't see it either because I did that. But that's it.
Call from
HPI, Hidden Field Investigate.
to accept.
Hidden Field Investigates. How are you doing, my friend?
Good. RA. Thanks for the request. Or I saw
Demand.
there was a
It was
request
a
for me
demand.
to. Yes. Okay. Well, here I am.
We summoned
the only. Thank you. The only real thing I wanted to add, I love the international flavor of your callers and in your audience. We've got Mathis, who's like super German, or he's European.
Germany.
Where is Mathis from?
Germany. You're right.
Oh, yeah. Okay. Oh, yeah. Okay. Then we've got Twin Tail, who's like from Iceland, which has a very unique accent. I love it. And then I forget who's the southern
Angela from Sweden.
Oh, Angela. That's how I pronounce it, from Sweden.
And we have.
And then who's?
We have a
from Texas. Who's the Southern Belle that just called in from Texas?
That was Amanda H. But I'm not sure if you knew this.
Okay,
Texas
Amanda
is still part of the U.S. right now. It's not a foreign country yet. They reserve the right to withdraw at any time. I'll let you know. We also have a whole host of people from Canada. We've got a huge Canadian representation.
Oh, yeah.
So We've got Sloth
Yeah.
Life from Scotland, Vivian Anderson from Scotland as well.
You know what, dude? You got to make a map. Not to steal from Joshua from Courtroom Confidential, but it might be neat to put some people on a map.
It's funny you say that.
Are you working on it?
We have one. We've got a map.
Oh, you do?
The mods can post a link. Everyone can post, their city where they're from. There's one link to post. Say, here's where I am. There's another link to see everybody. But it's
okay. You know what? Yeah. You know what? I remember seeing that and thinking, I don't think I want to be on this list. I don't like being added to lists. You know what I'm saying? It's like Big Brother watching.
That's when you come in with like
Scott
a pseudonym and you like pick a distant city as your city. Like Hidden Phil, you might go with something less recognizable, and then choose a favorite state you haven't been to and say I'll just be from there.
Yeah, I'll probably just say I'm from Wyoming and put myself on the map.
Because who would challenge you? There's only like 200,000 people there, and I don't think any of them have the internet. So you could. Sorry, just kidding. I've got a friend who's from Wyoming who is in part of our group here. So.
Oh, cool.
Wyoming's a good
All right,
place.
listen, I gotta go. I got a scam call I gotta do.
Okay,
Thank you.
before you go though, what's the next case? I know you've got your ear to the ground. There's some stuff happening both in your neck of the woods and around. What do you got your eye on?
Well, I was actually doing some rewatch of the squeegee was doing the case out of California. You see
the Menendez or
no no it's going on right now. The sorry, I forget
was that
the name
UC
of the
Irvine or whatever. I forget what the UC.
Yeah, it was the guy who stabbed like 3 people. But all of a sudden, like I don't think he was able to finish streaming that. Like all of a sudden, he was not allowed to stream it. So it looked like he had a new one going on that I haven't checked out yet. But yeah, no. In terms of new trials, I trust Josh is going to come up with a new tree trial.
Mm-hmm. We need a good foliage representation.
Yeah.
So
yeah,
that'd be good.
I trust whatever Josh is looking into.
I'm not sure if you heard, but I almost went live from Mount Airy, North Carolina this morning, where the manhunt was going on all over the weekend. I was setting up last night to go there. I was like, I'm about to load the car and drive the 3.5 hours to get there. I picked out my spot. I had all the scanner stuff set up. I had my air traffic control maps and everything that's going on. I had all the players. I knew where the headquarters were for launching all the searches and stuff. And they found the guy. I'm like, why are you so efficient? Awesome.
Horrible timing. Yeah, no. Actually, I remember when you were building your mobile rig, I remember you had kind of mentioned something about live trials and manhunts, and I thought, this reminds me of Cavalcante.
Yeah.
Like the excitement around that was like just palpable, and everyone was watching. And I think Scott's trying to get into that manhunt game, and I could tell your mobile rig was kind of geared for that. But yeah, sorry that didn't totally work out.
Yeah, if you know a guy though, if you could line something up. I'll.
Do you want me to commit a crime and go on the run? I'll give you. I'll give you info.
No, we are excited. I think we try to cover things a little different than anyone else does because I'm not trying to be anyone else. I've always been the tech guy, and we're looking to run cameras in both, pan, tilt, zoom, something we can watch from the scene and get news out about what's happening, as well as run thermal and night vision and some other things that we can all tie into the same stream and let people really experience what's going on and feel like they understand and know about what's happening, especially when there's a lot of uncertainty about what's happening in the neighborhood. What are the police doing, or is it safe to do this and whatever. So I love that scene. Hope to get involved in it in a legal way soon. So
yeah, exciting stuff. I wish I could stay in chat all evening, but I do have a scam call I need to attend to.
All right. I can't wait to get it.
I'll see you later.
Thank you, Phil.
Bye.
We'll see you. I love it. TYO Toys on Twitter is a great guy. Fun channel there. All right, Phil can give you an hour head start. That's awesome. All right, Thursday's the charm. But did you vote in the guilty, not guilty poll? If so, which way? Laura, I did. I think I've said it a couple times, but I'll say it again in case I wasn't clear. I don't like this case. I don't like picking either side. It just, because it feels wrong, right? Because Cyrus is dead. We've got a 14-year-old kid who died here. And it feels wrong. But I feel, after reading the laws in South Carolina, that sadly, and I say sadly because of the outcome, both of them were in the right. That I think both Cyrus and Mr. Chow were legally in the right to defend themselves. So we don't have a bad guy. That puts me in the not guilty camp. But I do think that this is something that could and will go to a civil trial, and justice would be accomplished there. And I think, as far as wrongful death, I think that's a very different case, because there's decisions made that shouldn't have been made. I think didn't rise to the level, in my mind, of criminality. But yeah, so I'm in the not guilty camp on this one. But it doesn't give me a lot of joy to say that, because I'm just very disappointed that this happened and it went this way. All right. Let's see. Here's what we're going to do. What time is it? It is at 7 o'clock. At 7 o'clock, we're going to, if we haven't seen any action, I think we're going to call it for the night, and we'll be on standby. I can go live in a moment's notice, and we'll, let's see, let me put that over somewhere. Oh, we'll be good. Yeah. And if there's a verdict tonight, we can bring it to you. Other than that, I think we're gonna have to come together again tonight, because even if they go home, there's going to be a meeting to decide whether or not they're going to let him go home, let the jury go home. So I think I'm bluffing here is what's happening. I'm bluffing, saying I'm going to call it, and nothing's happening. Community post if they go home. We could do that. The judge does not give us a lot of lead time. If there is a verdict or if there is a question, it just pops up and it's there. We've got, just seconds in some situations. So we should all expect a phone call. Yes. Hopefully you've all put your phone numbers in on the burner phone, so I can just call you all one at a time and individually welcome you back and let you know that the verdict's in. Got the bat signal at the ready. Thank you, Amber. You're amazing. Thanks for what you do. I know you're pulling like huge double shifts with your work and everything else. Didn't you do that once before when we had a verdict? Many times, unfortunately. Maybe Megan, maybe not. Yep, no verdict yet. You're lucky. Didn't miss it. This has been a crazy trial. It has. I would recommend, if you just joined us tonight and you've missed out on what happened today, I'd say go back and watch this morning. I'd love it if you watched our copy of it, because then you get all the reactions and the comments and things that happen from this community that you know and love. But the closings were worth watching. Those were very interesting. I mean, they're just from a purely legal standpoint, watching how they proceeded and the arguments that were made and the style, and the delivery, and the uniqueness that can only be South Carolina in the courtroom, it was impressive. I think you need to go back and watch that. All right. Expos from RA with alert. All right. Left to take a nap hours ago, and there's still no verdict. Not yet. Where we are right now, 6 hours, 25 minutes in 4 more minutes. 4 minutes and 40 seconds. We're going to be right at the 6.5 hour mark, which is a long time to deliberate on a single day. But this jury might be stopping to eat dinner right now, like for an hour, which is nuts, and then just keep going. So we might be back again later tonight. I think if I build a portal, this will actually be the quickest way. Watch this. Let me build a portal to the new. Okay, I'm going to build a portal, and this way I can just hit a button and go live. But I'm going to say it's not going to start until 8 p.m. Let's do 9 p.m. That's pretty late. We're not actually going to go live if nothing happens. But if you click on the, see, once this one ends, if you go to the next one and click the like button and then click notify, I think it will tell you when we go live. Members, subscribers, redirect, save. I'm not going to put verdict on there. I'm going to put verdict watch because I don't want people to think that there is actually a verdict. But no motion. We're 2 minutes away from 7 o'clock. I'm going to go to bed to make the jury conclude faster. See you tomorrow. Mathis, thank you very much for your call. Thanks for staying up late. When you go through the portal, click on the notify button. That's the best thing to do. We're going to have that up here in just a minute. Two minutes to midnight. Laura, you're hardcore. It's amazing. Can you leave the stream open and you just go take a dinner break? No, unfortunately, I can't on this one. But we'll leave a portal open so that all I have to do is hit one button and I'll be live. And of course, I'll have my phone with me, and I've got some amazing people that will contact me as soon as there's motion in the court that we can go live for. So I just can't get my jammas, at least not on the top half, because court could come back at any moment. All right. I think that's all. I think that's it. Dare I say play the music? Laura, it's time. It's time. This music, not the other music. Watching to see if the camera shakes while we're doing this. All right, what an incredible day in court with a very difficult, a very challenging case. One of the most difficult cases the jury ever has to decide. I don't envy them at all. I don't think they even like their own job right now, especially some of them. They want to go home. The judge just said no. He's kept them there. He's going to feed them dinner, and they might be there late. If you hear something, if you see something in the courtroom, if you see an update, let me know. We'd like to bring you whatever happens, whether it's a question or the verdict, live tonight, and we'll be watching for that. But going to camp out with y'all in the portal break room. Sounds great. Bring treats. Fine, I'll allow it. Thank you very much. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again for sure tomorrow morning, possibly tonight. The time on this new one, I don't know. We're just going to leave it open until I might actually change it to be like 10 o'clock. I don't think I'm going to stay up that late, but we'll see how late the jury stays here. Mama Bear of One, have a good night. Thank you very much. We'll be back here. We'll be back here shortly. You guys are amazing. We'll see you soon. Bye.
Thank you, sir. You're my new best friend.
There's nothing in the order that restrains you from talking to cats.
You are banished from the